All right. All persons who have existed before the Honorable Subject Judges, now presiding of the District of Columbia Court of Appeals, draw near and give your attention. God save the United States and this honorable court. This honorable court now in session. Come to order and please be seated.
Thank you. Good morning, all. We have 3 cases on the calendar this morning, and we will take them in the order they appear. The first case is United States versus EUGENE FACON. Counsel?
Thank you, Your Honor. Good morning, and may it please the court. Dan Lenners for the United States. If I might please reserve 4 minutes for rebuttal. It's good to see Your Honors in person again. The trial court made a clear and obvious error when it granted early release to EUGENE FACON, despite the fact that he had been fully vaccinated against COVID-19, particularly in light of this court's recent decision in Autry and the trial court's reasons for granting compassionate release, that some risk appeared to remain and the vaccine was not 100% effective of protecting Mr. FACON against COVID-19. The trial court's order was a clear abuse of discretion. This court has multiple jurisdictional bases to review that order, both statutory and under mandamus. I'll start with the merits of the case because the merits do bleed over into this court's mandamus jurisdiction should the court think it needs to answer that question. In Autry, the court directly rejected the exact reasons the trial court gave for denying the government's motion for reconsideration and granting early release to the defendant despite the fact that he had been vaccinated. The trial court granted release because some unknown risk appeared to remain and because the vaccine was not 100% effective. In Autry, this court directly rejected that reason and said that a prisoner cannot rely on the mere possibility of residual risks without evidence that those risks actually exist, apply to the prisoner, and rise to the level of an acute vulnerability. FACON gave no expert evidence, no studies, no other evidence to support the Autry standard. Because
I mean, how would he have? I mean, this was, I forget exactly when the initial ruling was, and then I think there was a supplemental ruling after they realized he was vaccinated, but we're talking something like March 21 or August 21 when it was revisited. There's probably not much by way of studies to say how effective the vaccine is at protecting people with conditions A, B, C, D. So what do you do when there's sort of a lack of scientific literature, and what is it that a defendant is supposed to do when they say, look, we don't know, that should be good enough. I'm at acute vulnerability without the vaccine, and we don't know that the vaccine does much good for these things. I know that might feel like a little bit of a burden flip, but I think you might kind of get past an initial burden by saying I'm acutely vulnerable without a vaccine, and the vaccine is a big question mark as to what it does.
I think the lack of studies, if that's the state of the world at the time, prevents the defendant from meeting his burden. It is the defendant's burden to show by preponderance of the evidence that extraordinary and compelling circumstances exist that warrant his early release. So the bar is already very high. These are extraordinary and compelling reasons, and he must show an acute vulnerability.
I suppose the way I'm pitching it is, what if he's gotten acute vulnerability pre-vaccine? And then the government says, well, hold up, vaccine changes everything. That seems like it might be on the government to show why, that he might have already carried his initial, to give an example, let's just say the government says, well, actually, now that it's spring, there's enough pollen in the air, and we think that's going to mitigate all the acute vulnerability that this defendant and prisoner has. And he can't show you studies to the contrary. I assume you would say, get out of town. You've got acute vulnerability and there's no particular reason to think that this pollen is going to do anything. And I suppose one reaction I have is, if there's nothing that says the vaccines are going to help mitigate the risks as to these particular ailments, then it's not so clear to me that it's on the burden of the defendant to debunk every possible thing that could be good about the vaccines if there's no evidence that they actually do anything. Does that make sense?
I understand the court's question, but I disagree with the premise that there was no evidence that the vaccines do anything. As of April 2021, August 2021, by that time, the government was submitting studies. Courts were routinely finding that the vaccines protected the majority of Americans against COVID-19, that they were effective at that time. I mean, I think it was in July or August of 2021 that the Seventh Circuit issued its decision in Broadfield saying a vaccinated prisoner faces the same risk as anyone else. And thus,
I think we took a little swipe at that in Autry, didn't we? We said, you know, maybe they should have waited a minute or two because then the Delta variant hit and it suddenly looked a little bit foolhardy, what Broadfield said.
I understood Autry to adopt Broadfield's reasoning in the sense that Broadfield left it open that a defendant could show he was nonetheless acutely vulnerable to COVID despite being vaccinated. I read those decisions as pretty consistent despite Judge Easterbrook's sort of back of the hand to certain arguments. But nonetheless, with regard to your question about what was FACON to do, as of the March, April, August of 2021 timeframe, the government was putting in evidence of studies and CDC guidance that the vaccines were highly effective. And that was sufficient to put FACON to, you know, leave the burden with FACON to show that he nonetheless remained acutely vulnerable. And so
let's assume you're correct that the trial judge erred in determining eligibility. I think I'd like to hear you get to the question of this court's jurisdiction to correct that error.
Yes, Your Honor. As we noted in our brief, we think there are three separate independent jurisdictional bases. The DC Code 23104 D2, which plain language would appear to apply here. It allows this court to review a decision entered by the trial court granting the release of a person convicted with an offense. Separately, if the court disagrees, it has jurisdiction under 11721A1 as interpreted by the Supreme Court in Carroll and this court in Stokes. That is the general grant of appellate jurisdiction of all final orders and judgments of the Superior Court of the District of Columbia. And in criminal cases, the Supreme Court in Carroll and courts across the country have found that that provides a jurisdictional basis for government appeals when the matter appealed is sufficiently distinct from the trial proceeding itself. And if the court disagrees with those two, it may exercise mandamus jurisdiction, both because the district court exceeded its authority in granting relief when the statute does not allow it, and because mandamus applies when there is a clear abuse of discretion, as both the Supreme Court and this court have routinely said.
If you'll indulge me, let's focus on your reliance on 11721A1. What do you want, the general rule to which this would be an exception? The general rule is that government appeals from in criminal cases are seldom permitted absent a specific statute authorizing the appeal. There is no specific statute that authorizes the government to appeal a compassionate release decision. The only statute is the general one of 11721A1, which may or may not apply. What do you take to be the rationale or the policy underlying the general rule against government appeals in criminal cases?
As I read it, Your Honor, it's a historical rule going back to the common law, if I'm understanding the Supreme Court's cases.
Well, I'm wondering, you see, whether that general policy, that rationale applies to appeals from compassionate release decisions. Now, I've built into my question a supposition that we should also address, which is whether this is in fact a criminal case. On that score, the case that we asked counsel to be prepared to address, the Robinson decision of this court, may or may not have some bearing. So if you would address, maybe you should address both those issues. Is this a criminal case? And if so, do the policies underlying the general reluctance to allow the government to appeal in criminal cases absent a specific statute, do those policies apply here?
Your Honor, we haven't taken the position in our pleadings that this is not a criminal case. No decision by this court that I'm aware of forecloses this court from finding it's a civil case. I will point out that the federal courts, as I understand it, are unanimous in concluding that compassionate release in the federal context is considered part of the criminal case.
Excuse me,
Is considered part of the criminal case.
well, I'm not sure that's true. In the DC Circuit seems to have thought that that wasn't true in Long, right?
I understand Long to have been analyzing a different issue, which is not whether that was a civil or a criminal case, but whether it was an appeal from a sentencing order. And the court said it was not an appeal from a sentencing order. It was not appeal. The defendant's appeal, the denial of compassionate release, was not an appeal from a sentencing order, but was in fact separate from the original sentencing order.
Didn't they also note that the Supreme Court has said that probation and parole appeals are civil, and a compassionate release decision has been characterized as a form of judicial parole?
That may be right, Your Honor. That's not an element of Long I had focused on. As I've said, the reason we didn't make this civil criminal argument was because, as I understand, the federal courts, they have said that appeals under 3582.
Well, the label, you're right, and the label may not matter all that much ultimately, but I just wondered what you thought.
I mean, the label may not ultimately matter. I mean, part of the teaching of Robinson is that there is similarly no express appeal provision in 23-110.
Well, Robinson relied on a case where that held that habeas corpus and 2255 appeals were civil.
Yes, Your Honor, the Williams case from the
So
Fifth
that's
Circuit.
the rationale of Robinson.
That's true, Your Honor, but I think Robinson is helpful here, notwithstanding the civil criminal distinction, because it didn't look for express statutory authority for a government appeal where the result of the government's appeal would be to increase the defendant's sentence. And a 23-110 proceeding, unlike a compassionate release proceeding, actually does look back at the validity of the initial trial and sentence. It's a constitutional question as to whether what occurred at the trial was fair. And so a compassionate release proceeding is even farther afield from the initial proceeding, insofar as it doesn't look at the validity of anything to do with the original trial.
That's the principle that the Second Circuit basically came up with in a succinct articulation in Peterson. Is that the test you would apply here?
It's not just the Second Circuit, Your Honor, but it's what the Supreme Court said in Carroll and what federal courts across the country, the First Circuit, the Fifth Circuit, and the cases that we cited have applied to decide whether the proceeding is sufficiently distinct from whether the proceeding being appealed is sufficiently distinct from the original trial to be appealable.
Because we're talking about jurisdiction, we'd like categorical rules. And imagine there's nothing that stops a prisoner, I take it, from filing a compassionate release motion the day after they're sentenced. And so the compassionate release motion, and let's just presume that prisoner is eligible. They have a debilitating disease, and the trial court that they're acutely vulnerable to contracting COVID and leading to death. And then they say, and I'm also not dangerous. And the compassionate release statute would then instruct the trial court judge to look basically at all the sentencing factors that the judge looked at the day before and come to a new assessment. That feels like it's very much intertwined. That's not the typical compassionate release case, of course, but it feels like that scenario could come up. And that feels very much enmeshed with the original sentencing. Do you not think so?
No, I don't, Your Honor, for two reasons. One is the courts, even if it looked at a compassionate release pleading filed the day after, is not saying, did I correctly sentence the defendant yesterday? It's not evaluating the merits of the sentence it imposed the day before. It is saying, looking at the circumstances as they exist today and going forward, is the defendant entitled to release under the separate statutory scheme? And second, as this court made clear in Bailey and Griffin, that many of the 3553A factors are not applicable to the compassionate release decision. So while the court could have taken into consideration deterrence and other factors that are relevant at the sentencing, the court may not take those into account the next day in evaluating the motion for compassionate release. So despite this potential timing issue, I don't think that the compassionate release decision is intertwined with the merits of the original trial sentence in any respect.
Does it matter that in, one thing that you don't highlight, but you might, is that really here it's the government that's defending the original judgment and conviction. And the compassionate release order is upending it. So do you think that matters at all? I mean, in one sense, you could say, look, we're not attacking the original judgment and conviction order. We're here to say, leave it in place. Don't mess with it. Is that something that figures into the calculus at all?
I don't think so, Your Honor. And I say that because when the courts look at whether 1291 provides authority for government appeals, and they do it somewhat routinely when a sentence or the amount of time a defendant would spend in jail is at issue, they've never characterized it that way. And the government isn't actually defending the validity of the original sentence for the reasons it was imposed. They're not saying Your Honor did it right the first time, which is different, for example, than a Rule 35 motion. A Rule 35 motion is a reevaluation of the merits of the original sentence. And so the government could defend that original sentence on the same basis. But
I think Judge Steele's point is not so much that the government in a compassionate release proceeding is defending the validity of the original sentence. I think the point is that the government, this is not a case where the government is attacking the original sentence or any original decision made at the criminal trial. And thus the policy of finality underlying the general rule against government appeals in criminal cases is not implicated here. If anybody, it's the appellant who's attacking the original sentence, at least in its continuation.
I mean, that's certainly a true characterization of compassionate release.
The defendant, I should have said.
But even if one goes to the Cohen collateral order doctrine itself and the elements that courts use when they apply Cohen, which the Supreme Court adopted in Carroll, all of those point toward this being the sort of separate order that is appealable by the government. The collateral order doctrine asked whether the appeal conclusively determines important legal questions completely separate from the merits of the underlying action and effectively unreviewable on appeal. And all of those would apply here if the government were unable to challenge this decision under the court's general grant of jurisdiction 11.
Can I ask you about your argument based on 23104 D2? As you know, Mr. Faison and amicus have focused on the legislative history and the similarity of the language to the language in the federal statute and the federal cases holding that federal statute looks at or authorizes appeals only in situations involving release for a temporary period, pre-trial or pre-sentencing and the like. You say, on the other hand, we should look at the plain language. What I want to ask you is this: can you think of a reason why the counsel if its attention had been drawn to the language that's an issue now, would have not wanted to treat a release order in a context like we're facing now. Obviously, compassionate release postdates that by many years. But if they had been able to envision that, why they would not have wanted to treat it the same as release orders involving more temporary release situations.
I can't think of any policy reason why the council would want compassionate release, orders granting compassionate release to be unreviewable, which is effectively the result of the defendant's arguments. The defendant says there's no statutory basis, mandamus is not appropriate, and thus an order granting compassionate release is entirely unreviewable by this court on appeal. And I can think of no reason why the council would want those sort of decisions to be unreviewable. And I think that
you agree a Rule 35 grant is not reviewable, right?
This court has said that. Not every court agrees.
Okay. And you would agree that a judgment and commitment order that sentenced the defendant only to time served is not reviewable under 23-104, even though that has the effect of immediate release as well.
Yes, initial sentencings are not reviewable on appeal, but this is a different statutory scheme in which a defendant has been sentenced to a period of incarceration, often under a mandatory minimum, not always, but where the legislature has said this crime carries with it a set term of years or life in prison. But the compassionate release allows a court to overcome those mandatory minimums and release.
Yeah, I guess I get that. And I'm just wondering why, if 23-104 is meant to permit government appeals from all things that, a compassionate release order is not actually an order to release, it's a modification of a sentence. It doesn't direct a DOP to release anybody, it adjusts the sentence in ways that, as I understand it, are occasionally imprecise and don't lead to the individual's actual release. But put that aside for the second. I guess I wonder why you're sort of asking us, well, they'll take a functional look at it. And what it really is doing is letting somebody out. And that has some appeal to it when I read 23-104. But then I think, well, take a functional look at a time served sentence. Did the council mean to permit government appeals from those? And I'm not sure I've heard the answer. Could you just repeat it for me?
Well, my answer to that, Your Honor, is it's just no one would think of an order imposing sentence at the end of a criminal process that is of time served as a release order. That just seems like a tortured view of the English language.
It's letting the guy go. He's been held for a long time, and now, okay. Or how about 6 months ESS? It's all ESS, but time served. It's suspended. Is that closer to feeling like the release order to you?
No.
Why not?
Because it's a imposition of sentence. No one would call that a release order. The release order.
He's going home. He's walking out the courtroom. I mean, once the judge has said that, process him out. That's kind of the effect of it. No.
The practical effect is that the defendant walks out, but I don't think that a normal use of the English language would think that the council would think of that as a release order. In contrast, and this is the timing issue that Judge Thompson highlighted, the 23-104 D2 was enacted before the Compassionate Release Act. And the council could have very easily, and we think did, contemplate that a release order under the Compassionate Release Statute, which is called compassionate release, in which this court has said in Bailey, a court has no discretion but to release a prisoner if he meets the elements. The council could have anticipated those orders would be appealable under the plain language of D2.
Do you think an IPA grant, this defendant is innocent under the IPA, would be appealable under 23-104 too? Post-conviction, trial judge sees DNA, says he's out, acquitted. It enters a judgment of acquittal. Do you think that's appealable because that also releases somebody who's in the middle of a sentence? I don't think we've answered the question. I'm just curious what you think.
I think that's a harder question. It's not something I've thought about. Certainly that seems to go to the merits of the underlying trial. And so the council could have anticipated that is not in fact a release order, but is in fact, entry of new judgment or something like that. But I don't think the court has to address that issue here. But again, if the court has concerns about its jurisdiction under D2, we think there's a very strong argument for jurisdiction under 11.721.
Regarding,
there's
if I may
mandamus.
ask you, regarding 23-104 D2, there's a federal statute that's an analog to that. Am I correct?
Yes, sir.
Has any federal court held that a compassionate release decision was appealable by the government under that federal analog?
Not that I'm aware of, Your Honor.
Not that I'm aware of either. But
From what I've seen, there have been government appeals in federal cases involving compassionate release. The 10th Circuit cited 1291 as the basis for its jurisdiction. It didn't analyze. The 6th Circuit in a couple of government appeals, one is Sweet. I think there was a second, simply didn't cite the source of its jurisdiction. So it's not clear to me that, even though no federal court has accepted the argument, it's not clear that's been presented to any federal court, and certainly hasn't been rejected in the compassionate release setting.
were you about to go to mandamus? Is that what
I'm
you were
happy
about
to address
do?
mandamus. Mandamus relief is also appropriate. The defendants suggest that mandamus is not available when the underlying decision is a discretionary one, but that conflicts with Supreme Court precedent that has been cited by this court, Schlegenhoff and Banker's Life, which this court cited in Stebbins and Banoff, to say that mandamus relief is available when there's a clear abuse of discretion. The defense also suggests that mandamus relief is not available unless the right is clearly indicated at the time the trial court acted, I think is how I understand their brief. And this court rejected that argument implicitly in Banoff. And Banoff, the plaintiff or the attorney sought to mandamus the trial court judge. And this court said that a bankruptcy order that had been issued 2 weeks before oral argument in the case provided a basis to grant mandamus relief because it eliminated all jurisdiction or all discretion from the trial court.
So I had understood the principal argument of the defense to be, look, if you don't have jurisdiction to hear the appeal in the normal course, you don't have mandamus jurisdiction either. That I think they're quoting from Will, it may never be employed, the writ of mandamus may never be employed as a substitute for appeal and derogation of the legislative constraints on government appeals. And that makes a lot of sense to me. Is it, if we don't have jurisdiction to review this under some statutory hook, is mandamus really just like does it really just blow the doors off of jurisdictional restraints on us?
As I understand mandamus, the court may exercise it in aid of its jurisdiction, which means that if there's no jurisdictional basis, but it's reviewable under, say, the collateral order doctrine or some other reason, this court may review it. I mean, that's what the approach the court took in Stokes and in Fitzgerald. It didn't resolve, if in Stokes it found no statutory basis, but it reviewed the government appeal under mandamus.
But Stokes was also a case where the trial court had no authority to do what it did, not an abuse of discretion type case. And that's what we said. We could, I take it, we might step in, maybe there's no authority to conduct a review because the trial court just did something that was totally unenvisioned by the statute, and we will step in and say, you can't do that. Here, there's no question the trial court could do this. They can grant compassionate release. That's well within their jurisdiction. And that seems like some constraint on mandamus review. Like one is saying, this is a power that you trial court do not have. Okay, that makes sense to me as mandamus. Another is trial court, you have the power, but looking at it, we think you've abused your discretion. Feels a lot like a giant end run around jurisdictional constraints to me. Does it, what's left? What's left of what we usually say that we need to have jurisdiction over a case if you can just backdoor everything in through mandamus if it's, quote unquote, especially wrong?
Your Honor, I think that's mixing apples and oranges, which is the basis for granting mandamus relief, which is a clear abuse of discretion or no authority. With the question,
can I ask, do you think that the defense and the government can appeal evidentiary errors mid-trial, a clear abuse of discretion for a hearsay ruling? Do you think they can take that straight up?
No, the defense may not, because the the court has said mandamus may not be used as a substitute for appeal. So if something can be ultimately appealed, mandamus may not be used.
But the government can?
The government could try. I mean,
You think it would be appropriate?
I think that it would be hard to find a evidentiary ruling that was so wrong.
I've read a lot of transcripts, counsel. It's not that hard to find, let me tell you.
And I would point out that in Moultrie, this court found, it said that the court is not enough to say that the court has power, and therefore mandamus may not issue because the court had jurisdiction. The court said the issue is power to quash for the reason given. So
Well, there is a statute that deals with the, am I right? That deals with the situation Judge Deal has posited and provides for permissive government appeals, 24, am I wrong? What 24-104 B?
I know there are elements of 24-104 that allow for government appeals mid-trial and allow the trial to be paused. I don't know if those are evidentiary rulings or other types of rulings. I'm not that familiar with the statute, Your Honor.
Oh, well, it's which suppresses or otherwise denies the prosecutor's use of evidence on the ground that it was invalidly obtained. So it doesn't apply to all evidentiary rulings. I see your point.
It's more suppression issues that arise
But the
mid-trial.
implication is, well, did you want to save some time for rebuttal?
Yes, Your Honor.
How much time did you want to save? 5 minutes?
I asked for 4.
Okay.
Thank you.
We'll give it to you. Let us hear from one of the parties or amicus.
Thank you, Your Honors. PDS is going to be focusing on jurisdiction.
You may take your mask off so that we can all understand you if you feel more.
Thank you, Your
comfortable
Honor.
with that.
PDS will be focusing on jurisdiction, and I respectfully ask that they argue first.
That's fine.
Thank you.
Good morning. May it please the court. Daniel Gonan on behalf of the Public Defender Service. So I want to begin, if I may, by pointing out a few areas in which I think Mr. Linares and I agree. Compassionate release is a criminal proceeding. Long actually held it was a criminal proceeding on page 177. It held we can't, there was an argument about whether something was subject to plain error review, and they said this is a criminal case, not a civil case, so we have to apply the criminal plain error review. And I agree with Mr. Linares that all of the federal courts that I'm aware of have said compassionate release is part of the criminal case. And this court said that in Bailey, actually, when it held that the defendant's burden is a preponderance of the evidence. It said the reason that's so is it cited Cigna, which is a civil case, saying that's the default evidentiary burden. And then in a footnote, it said, well, this is a criminal case, but when the burden of proof is placed on a defendant in a criminal case, that also defaults to preponderance of the evidence. So Bailey reached that issue and held this is a criminal case. And I don't think that the rationale of Robinson applies. And I do want to correct one thing Mr. Linares said, because 23-110 does have an express appeal.
I'm sorry, you don't think the rationale of
Robinson? 23-110 does have an express appeal provision. It's 23-110F, which was enacted in 1970s when 23-110 was first enacted. And it says that an appeal may be taken without specifying party in the same way as appeals in habeas corpus proceedings. In 1963, in a case called Andrews, the Supreme Court interpreted the identical language in 2255D to say that because habeas has this very weird status as, at least in some ways, treated as civil and was therefore outside the common law prohibition on government appeals in criminal cases, that when Congress used that language appealable as in a habeas case, it was incorporating the notion that the government can appeal grants of, in Andrews, there was a 2255 motion, but it's basically the identical language as in the 23-110 statute. So I do want to address, I guess, I'll begin with the collateral order doctrine. And this is the judgment, this is an appeal from, in effect, a final judgment in a criminal case. The sentence is the judgment. That's what this court and the Supreme Court has said. In Berman, the Supreme Court said, quote, final judgment in a criminal case means sentence. The sentence is the judgment. And this court said in a case called Long, 163A3rd 777, in this jurisdiction, as in the federal courts, a sentence is integral part of a judgment. So that, and in Long, the issue was when the judge granted an amended sentence, did that permit the defendant to seek a new 23-110 that was not barred as second or successive? And the court said when the judge imposes a new sentence, even years later, not only is it imposing the new sentence, that's actually reimposing the conviction and the sentence so that you can then challenge the underlying conviction from that amended sentence. That was the holding of Long.
I mean, that seems a little formalistic to me, counsel, in the following sense. Yes, in a way, you could structure the statute that way, and that's the way the compassionate release statute works. There's actually a JNC that's modified. Just imagine that it was structured slightly differently. And frankly, I don't think there's any reason to think the council cared about how it was structured. And instead of touching the original JNC and modifying it, instead what it does is it gives the trial court judge authority to issue a superseding order that trumps whatever the judgment and commitment order says. And that superseding order is what controls, if the defendant's going to be released or not. You haven't touched, if that's how they structured it, it would no longer be true that you've amended or touched the original JNC, but it would look identical to this. And the distinction between those two scenarios seems totally formalistic and meaningless to me. So I wonder, what is your reason for thinking, if it was the second scenario, if there's just some new order that issued and said, actually, instead of 10 years as initially, I've re-reviewed everything now 5 years later and think he's ready to go. And so I'm issuing a superseding order saying 5 years is the only sentence for it. The other thing I'm not touching, I'm leaving it in place, but this is the superseding order that I'm authorized to issue. Why is that not? I mean, it feels very collateral to the issues at the original sentencing. It feels very collateral to the original conviction. Why isn't it?
So I have a couple answers. So the first answer is in Carroll, and I'm going to paraphrase this only slightly. The court said in a limited sentence, when we're talking about appealability, form is substance. That's a direct quote. Form is substance because Congress, or in this case, the council, specifies what orders are appealable by categories, and they use the form of the order to specify the category. And in Carroll, the government argued the Carroll was an appeal from a suppression ruling. And the government said, well, yeah, this is a suppression ruling, but without this evidence, we can't proceed with the case. So it's the functional equivalent of a dismissal of the indictment because this ends the case. And the Supreme Court said, too bad. That may be true, but that doesn't mean you get to appeal it under the provision for dismissal of an indictment. This may be the functional equivalent of the dismissal of an indictment, but it's actually an order granting suppression. And that's not within the categories that Congress has specified the government can appeal from. At that time, the statute's since been amended. The second answer to that question is, I think even the sort of alternative universe you posited, that would still be, affecting the sentence in the criminal case. I mean, if the sentence is not being carried out, cannot be carried out, to say that's somehow not affecting the sentence.
Yeah, but then it starts to feel an awful lot like Robinson, right? I mean, I guess I don't see, Robinson was a modified JNC to run, it had once been issued that it was going to run consecutively with the sentence in a different case, and then the judge modified it, say, actually, we're going to do it concurrently with the other case. And then there's a 23-110 grant, the government, that is the 23-110 grant, the government appeals. It feels kind of close to being on all fours. I mean, I think that case actually did modify the original JNC, if I'm not mistaken. I'm not sure if the case is totally clear on that. And so why doesn't Robinson preclude us from saying that would still be an unappealable order?
Well, because Robinson is based on a specific statutory authorization in 23-110F. And
they don't mention 23-110F, right?
I'm sorry?
Do they mention 23-110F in that footnote?
They cite 23-110. They don't specify a subsection, but it's in there. And they cite Williamson, which is a case that talks about how, a federal circuit case that talks about how in the 2255 context, this notion that the government can appeal habeas corpus cases is carried over by that statutory language that's in 2255D. The same language that's in 23-110F. And also they also say in that footnote that it was conceded that the court had jurisdiction. So I don't think there's maybe.
I was wondering if you were going to say that, because it's not so. They say council agrees that we have jurisdiction. They don't say which council agrees. I mean, I suppose the most fair implication is that it's probably the party I guess the government in that case didn't need to agree because they brought it, so they would have to, and the implication would probably be defense counsel agrees.
Sure.
But we've also, we entertained, we've entertained 23-110 appeals from the government dozens of times. That's the only case I found where we even made any mention of jurisdiction. It didn't seem to cite a statutory hook. It seemed to just sort of say, okay, like we can take this.
Yeah,
So
sorry.
go ahead.
I didn't mean to interrupt, but Little is the United States v. Little. 851 a second 1280 in footnote 1. They say 23-110 motion is appealable by the government, citing Robinson and citing federal case law. So again, I just don't think that's ever been a controversial point. But what was true is that a Rule 33 motion granting a new trial was not appealable by the government until it was expressly added to the statute. In fact, you'll see in the legislative history of the same statute that added D2, subsection D2 added an appeal provision allowing the government to appeal the grant of a new trial. And the reason for that was both the OAG and U.S. Attorney's Office said, we can't appeal these things right now. They're not appealable if the judge grants a new trial motion under Rule 33. We have to go to trial and then maybe we can appeal it. And all of the federal circuits, again, before the analogous federal statute was amended, all the federal circuits said a Rule 33 grant is not appealable, even though a new trial granted under 2255 is appealable. But that's because there's a statute that authorizes the appeal for the 2255 or 23-110.
That causes me to ask you the same
Sure.
question that I asked your opponent, which
Right.
is, can you think of a reason why the council would not have wanted in enacting 23-104 D-2
Right.
to include release orders of the sort we're concerned with here,
Absolutely. I mean,
as well as temporary release type orders?
sure. So, I mean, expedience is the key issue here, right? The council enacted the compassionate release statute as an emergency statute and enacted it a couple of times, reenacted it as an emergency statute. I think, frankly, the council might very well be kind of disturbed to think this is a defendant who applied for compassionate release in December 2020, right after the permanent legislation, I think before it even went into effect. And almost 2 years later, that defendant is still sitting in prison, even though the judges made the findings that would warrant his release. So expedient, the council wanted these motions to be adjudicated quickly, and they had trust in Superior Court judges that they were going to not go rogue and do something crazy. And I don't think that the government is contending that that has happened. I know they sort of dispute the dangerousness finding, but not particularly vigorously. And they didn't dispute that there were extraordinary and compelling reasons at the time the motion was adjudicated, which I guess is a way to turn to mandamus. Because
well, before you get to mandamus, so the desirability of an expedient of expedition is an argument certainly in favor of an expedited appeal, but I'm not sure it's an argument against the right to appeal for the government. What policy do you think is being served other than expedition by a rule against government appeals of compassionate release decisions? It can't be, it doesn't seem to be the policy that that motivates the general rule against government appeals of criminal convictions. And that's one reason I think that Carroll and Peterson set forth a standard that would work, or might work, in favor of allowing appeals from compassionate release decisions as appeals from final orders.
well, I guess I would object to the whole notion that the way to decide whether something is appealable by the government is to look at the policies behind it, as opposed to what the Supreme Court and this court have said, which is, has the legislature authorized the appeal? Those policies.
Well, I looked, I raised it, I put it that way because the Supreme Court in Carroll basically said something similar. We understand the general rule, government doesn't get a chance to appeal a criminal conviction.
Mhm.
Okay, that's because of concerns about finality and the like. But here, those sorts of concerns and rationales simply don't apply. And the court said that when something is sufficiently collateral to the, it didn't use the word collateral, but that's the word people have used. When a ruling is sufficiently collateral to the main course of the prosecution, it is appealable as a final order under the general final order statute.
Mhm.
And this seems to be pretty collateral.
So it's not collateral. I mean, we can talk about the policy issues because one of the things the Supreme Court talks about is a general kind of distrust of the government. And in Manypenny, it talked about, you know,
I'm sorry, I didn't catch the last thing you said.
in Manypenny, the Supreme Court case Manypenny,
Yes.
page 246, it talks about, you know, there's a prudential concern about individuals being free from harassment and vexation of unbounded litigation by the sovereign. It's hard enough, let me tell you, it's hard enough to go against the government in Superior Court and win. Most compassionate release motions are denied. But then to win and then have to go through a second round on appeal, that is exactly the concern that the Supreme Court is talking about with Manypenny. And in the case called DeBella, it said, yes,
Well, it's the defense. The difference is that in a criminal case, the defendant is being hauled into court in the first instance by the government. And so we say, all right, look, enough is enough, you know, this is a big deal.
Mhm.
But here, this is a case where it's the defendant who's initiating the proceedings, who's saying, well, you know, I'm the one who wants to go into court here. It seems a little bit different.
Well, you can say the exact same thing about a Rule 35 motion, which the government concedes is not appealable by the government. You know, the same thing. It's not saying the original sentence was wrong. It's not attacking the underlying conviction. It's not.
Well, a Rule 35 motion, I think, does basically ask the court to reconsider the original sentence based essentially on the facts as they were.
That's not true. The
Fine.
court can consider.
We've said that,
Yeah.
but I don't know how accurate that was. And it's, you know, it is generally, I think, understood that Rule 35 is not the place to say, well, look at all this, look at all the water under the bridge or over the dam. Since my original sentencing, I've really reformed, my life has changed and so forth. Redo my sentencing. That's not the basis for a Rule 35B motion, I don't think.
I disagree. I think this court has said basically the judge can consider any factor, even if they just
You did
think.
say that, I think, or something.
And I would point out, the Supreme Court just decided a case a few months ago called Concepcion, in which they considered a sort of similar issue, whether at a sentence modification proceeding, the judge can consider Concepcion concerned resentencing due to changes in the crack cocaine powder disparity that had been fixed but not retroactively. And it said, okay, if you can seek resentencing as if the revised, as if the disparity were eliminated. And the issue wasn't Concepcion whether a judge can consider all the things that have happened since the original sentencing, or can only consider the changes to the disparity. And the Supreme Court held it can consider whatever it wants. It can consider the defendant's good behavior in prison. It could consider the defendant's bad behavior in prison. It can, it's just, unless there's a specific limit, statutory limit on what the court can consider anything it will consider at the original sentence. So in Concepcion, the judge actually said, well, the crack powder disparity had nothing to do with the sentence I gave you originally. And you're pointing me to your great prison behavior, but I'm not allowed to consider that. And the Supreme Court said that was wrong. So, you know, I don't think there's really any distinction between a Rule 35B and a compassionate release that holds up to any kind of scrutiny. I see my time has expired. I don't know if the court wants me to address mandamus. There was
Take a
one-
minute to address
Okay.
mandamus.
Just before I forget, I do want to point out, everyone agrees that the court can't grant a compassionate release motion while the direct appeal is pending. So I think that tells us all we need to know about how it's not collateral to the final judgment, because when the final judgment is subject to appeal in this court, the Superior Court lacks jurisdiction under Bell v. United States to grant that motion. Bell said, you know, Rule 35B granted during the pendency of the appeal is null and void. So how can it be collateral when the judge can't grant it if the judgment is on appeal in this court? It is.
Have we said that?
I'm sorry.
You say everybody agrees, and maybe that's right. We haven't addressed that issue, have we?
Well, the court addressed that in this case where it remanded, there was a motion to remand, and at least implicitly, the court agreed that a remand was appropriate for the purpose stated. The government certainly hasn't disputed that. And I think the government actually took the position in their opposition to the original compassionate release motion. They took that position that the court could not grant it during the pendency of the appeal. So they've waived any argument to the contrary. I'm sorry, does the court still want me to take a minute on mandamus?
I beg your pardon?
Does the court still want me to take a minute on mandamus?
Take a minute on.
Okay. So the key to mandamus, I think, lies in the procedural posture of this case. This is a motion to reconsider. The government expressly conceded at the time the original compassionate release motion was filed and granted that there were extraordinary and compelling reasons under the statute. It was only after the judge made his findings and issued a ruling that the government then moved to reconsider those findings based on information it could have presented in opposition to the motion, but elected not to. It even said in its opposition, vaccines are going to be rolled out on McCreary in early February, but it didn't say, and that's a reason to deny compassionate release, or you should wait a couple of weeks to see what happens. It just said, yes, we agree there are extraordinary and compelling reasons due to his medical conditions, but you should deny this motion for different. So there's a total waiver of extraordinary and compelling reasons in the trial court. In the motion to reconsider, the government basically takes the position that the court cannot grant compassionate release to someone who's been vaccinated unless maybe they're immunocompromised, which is a position that this court rejected in Autry. The government was relying on decisions like the Seventh Circuit's in Broadfield that, as Judge Field put it, this court took a swipe at in Autry. So the rationale for the legal rationale for the government's motion to reconsider is actually incorrect under this court's precedents. But the key is on a motion to reconsider, the burden is now on the government. This court has said the movement in a motion to reconsider bears the burden of showing that the original findings should be reconsidered. So the government has to come up with the evidence saying the finding that you made that we didn't dispute has to be reconsidered based on information we could have presented to you but chose not to, and we're now choosing to present it to you. I don't think any litigant can walk into court and say, we had all this evidence, we chose not to present it, but that's because we really didn't think you were going to, find against us. But now that you have, we'd like an opportunity to present this evidence we chose to withhold. You just can't do that in Superior Court.
Well, that seems like a fair point procedurally,
Mhm.
sort of a black mark against the government. But I wonder whether in the end, that means we shouldn't, if we think this thing is the error is stark enough, just apply Autry the way we see it should, the way we say and think it should have been applied. Either in evaluating the merits of the judge's decision. I mean, it's hard to ignore what we said in Autry.
Right, but Autry is in the context of an initial compassionate release motion where the defendant has the burden. Everyone agrees with that. And everyone agreed, or at least the government agreed.
I understand that point. But in the end, we might well be in a position to say, look, we have Autry, and we can see the defendant did not meet his burden here, and the judge did not make the findings in Autry. I'm not sure that the procedural wrinkle you pointed to precludes that, or should preclude that.
It absolutely does, because remember, the government didn't dispute the extraordinary and compelling reasons at the initial stage. So Autry would not be it's a waiver, right? Like if you waive something and there's a subsequent change.
So you treat it as a complete waiver of the ground.
Absolutely. I mean, it's unambiguous. They say yes, his diabetes and obesity put him at increased susceptibility to COVID-19.
Refresh my memory, if you would, in the briefs on appeal. Was this waiver of Autry argument made?
Yes, I believe Mr. FACON argued in his brief that in the context of a motion to reconsider, the government's arguments came too late because they were first raised in the motion to reconsider. And
Well,
again,
at the time the motion was originally before the court, Mr. FACON had not been vaccinated, correct? Vaccines
correct.
weren't available probably. And there was at least some question, I suppose, as to whether, given his particular conditions, he would have been advised not to get a vaccine.
Mhm.
The change came when the vaccine became available and he got the vaccine. I mean, doesn't that change the whole situation for the government?
Well, again, he got the vaccine before the judge made his findings, and the government knew that the vaccine was getting rolled out in early February. And I don't think it's disputed. And it's actually clear from the record. They can pull up, the government, that is, can pull up an inmate's vaccination records on their computers. When they filed the motion to reconsider, they attach Mr. Faison's vaccination records. The date they pulled it up was March 9th. So they got that basically the same day. For us to find out, for an attorney to find out if their defendant has been vaccinated, you have to, first of all, think to schedule a legal call. That can take weeks. And then you have to wait for the legal call. And then you can ask your client, hey, just checking in, have you been vaccinated yet? And I can tell you one way or the other, assuming they even understand, what the vaccine was and what they got. So the government absolutely had the ability to discover if Mr. Faison had been vaccinated. They knew, they said in their opposition, vaccines at this particular facility are going to be rolled out in early February, and Mr. Faison is in the highest priority level for inmates to receive the vaccine. So they could have checked, they could have said the imminence of the vaccine is a reason to deny compassionate release. They could have said, by the time you rule on this motion, he will likely be vaccinated, so you should check in with us to see if that's happened, or you should delay ruling until after we've determined if his vaccine was granted. They could have made any of those arguments, and they absolutely did not. So it comes way too late. And in the context of mandamus in particular, this court would have to say the judge not only had no discretion, but to grant a motion to reconsider, which I don't think there's any case saying a judge is required to grant a motion to reconsider, certainly not in this circumstance, but that it was an abuse of judicial power not to grant a motion to reconsider. And this court has to look at any conceivable reason Judge Lopez could have given to deny the motion to reconsider, because the court would have to say he had no choice but to grant it, that there was only one option, and that it was an abuse of judicial power. And I disagree with Mr. Laniers that any sort of thing that you might call a clear abuse of discretion warrants mandamus, because that would essentially turn mandamus into just a form of appeal in a situation where the council has withheld a right to appeal. And in Harrod, Judge Farron's opinion in the en banc case of Harrod, he talked about how mandamus is reserved for abuse of judicial power as opposed to abuse of acknowledged discretion. And Mr. Lanier says, well, look at Moultrie. And Moultrie says, yes, a Superior Court judge has a power to quash a grand jury subpoena, but not for any reason. So just because the judge has the power to do it doesn't mean he has the power to do it for the reasons given. But here, of course, Judge Lopez absolutely had the power to grant a compassionate release for the reasons given. In fact, it wasn't disputed that he could grant, or at least that he could find extraordinary and compelling reasons and grant compassionate release. And in Will v. United States, the Supreme Court said it's a semantic fallacy to say that the court lacked the power to issue a ruling if its ruling was based on erroneous reasoning, right? Because then that would just turn it into a substitute for an appeal. So I think the analog to Moultrie would be, suppose a judge says, I think, I can grant compassionate release without finding an extraordinary and compelling reason. In fact, I don't think there's an extraordinary and compelling reason, but I'm going to grant it anyway. I think I have the power to do that under the statute. That, I think, would fit into kind of the framework for mandamus relief. Because yes, the judge would have the statutory authority to grant sentence modification, but without making those findings, he can't do it. But just to say that the judge, may have applied an erroneous legal standard or made a clearly erroneous factual finding in the course of doing something that's in the heartland of what every judge does in compassionate release cases, look at medical conditions and COVID and determine if there's acute vulnerability, which is what Judge Lopez did. So to say a clearly erroneous factual finding or an erroneous legal standard warrants mandamus relief in that context, that's an appeal right. That's giving the government an appeal right. And the Supreme Court and this court have said over and over again, mandamus cannot be used as a substitute for appeal, does not reach the gauntlet of reversible errors. And a finding that of error or even gross error is not enough to justify mandamus relief. It has to be an abuse of judicial power. I see I'm well over my time now. So unless the court has further questions, the appeal should be dismissed and mandamus should be denied.
Thank you, Your Honors, and may it please the court. I'm Hillary Smith on behalf of the appellee Eugene Faison. This court should dismiss the government's appeal for lack of jurisdiction, or in the alternative, affirm the trial court's reasonable exercise of discretion in modifying Mr. Faison's term of imprisonment. The judge's determination that Mr. Faison presented extraordinary and compelling reasons for release and that he was rehabilitated and not dangerous are quintessentially discretionary decisions that were well-founded on the record before him. The government has failed to show that either decision was an abuse of discretion. The judge's determination that Mr. Faison, a 57-year-old Black, obese, diabetic man with hepatitis C and hypertension, met his burden to show that he had extraordinary and compelling reasons to warrant a sentence modification, was well-reasoned and presented and founded on evidence that Mr. Faison presented. At every point in this litigation, and indeed even when the council passed the permanent legislation on compassionate release, everyone was aware that vaccines were imminent. The government, as PDS has noted, had represented that vaccines would be at BOP facilities in mid-February of 2021, and that Mr. Faison would receive one quickly on account of his age and medical conditions. The trial court expressly discussed this fact in his March 2021 indicative order. The government conceded that Mr. Faison met extraordinary and compelling reasons at that time and did not argue that the ruling was an abuse of discretion, and even said that the court applied the right standard when he looked at whether Mr. Faison had heightened susceptibility to COVID-19. When the government made its motion for reconsideration, the only thing that had changed is that the imminent vaccination became an actual vaccination. But none of this was actually new. Indeed, the clinical studies and journal articles the government offered almost all predated the court's indicative order. And the judge had already determined that Mr. Faison presented extraordinary and compelling conditions because of his age and 4 separate severe medical conditions, even once vaccinated. The judge did not.
So let's just stop on that last clause, even once vaccinated. What was the evidentiary basis to say he remained acutely vulnerable even once vaccinated?
One basis, Your Honor, is his age. Elderly, even close to the age of 60, which would actually put him eligible for an entirely different section of the compassionate release statute. Another factor is his multiple.
I suppose what I'm asking is, I agree, and really take no issue with Judge Lopez's ruling that he was acutely vulnerable prior to being vaccinated. It turns out that when he initially granted that compassionate release, Judge Lopez was ruling under the misimpression that he was not vaccinated. I believe everybody was, when in fact at that time he had in fact been vaccinated. What is the evidentiary basis to say that the vaccination didn't severely mitigate to the point of him no longer being acutely vulnerable, his risk factors?
So what answer, Your Honor, is how at risk he was, both because of his age and because of his 4 separate medical conditions. Your risk increases the number of medical conditions you have. With respect to vaccines specifically, Mr. Faison did present studies indicating that the vaccine was less effective in people with obesity. That study indicated that people with obesity produced half the level of antibodies as people without. In his original motion, he presented guidance from the CDC indicating that obesity weakens your immune system and can weaken its ability to respond to the vaccine. He also presented a study indicating that diabetics have dysfunctional immune responses and again could fail to effectively control infections. And he also presented Dr. Fauci's January 2021 warnings about variants, pointing to what was then known as the South African variant, which later became known as the Beta variant. And the fact that the CDC was already warning about potential waning immunity and reduced effectiveness of vaccines against variants. Certainly by the August 2021.
So I mean, that tells me, remind me what the statutory language is. I thought I had it, but I actually don't have it in front of me. It's what, extraordinary circumstances, and just fill it out for me, because isn't it that they're acutely vulnerable to death and serious, it was death and something else? I forget exactly what the phrase is.
Acutely vulnerable to severe illness or death from COVID-19, Your Honor.
So, I mean, you've listed a lot of reasons to think, even after vaccination, Mr. Faison is, I forget how to pronounce his name. Could you remind me?
Mr. Faison.
Mr. Faison. Even after vaccination, Mr. Faison is at an increased risk as compared to the general population. The number of risk factors put him at a particularly increased risk. I get all that. There's compounding reasons to think he's at an increased risk, and maybe a quadruply increased risk. I'm not sure how the multiplier works. But how do we take all of that and say, and I guess like, again, it's sort of what's the evidentiary basis for that increased risk left him acutely vulnerable to death? Is it just, acutely vulnerable just means more than the general population or many times more than the general population?
Well,
I mean, if the government comes forward with studies that say, actually, the chance of death is very, very little once you've been vaccinated, that seems like they've gotten around acute vulnerability, even if your client is severely more at risk and, he's 0.008 times likely to die as opposed to 0.001 or something like that.
well, the government presented studies that, the clinical trials from what was then a very new vaccine against a novel coronavirus. And at that point, it indicated that in those clinical studies, it appeared to be highly effective for about 2 months. And so that's what they presented. And the judge looked at that evidence and said, given how at risk Mr. FACON is because of all these things I've already found in my March order, and given this Mr. FACON's pointing out these studies that indicate he might not respond as well to the vaccine as people in these clinical trials were. He's still very much at risk due to his presence in the prison system, which is very much unlike the clinical trials. We don't know how long these vaccines will last. CDC was already warning about waning immunity. As of July 2021, the CDC had indicated there were variants of concern and there was discussion about boosters. So I think, yes, the government did present some evidence, and Mr. FACON countered that evidence with why he remained at risk because of his particular risk factors, which is exactly what Autry directed the Superior Court to analyze.
I think one difference, the government might say, but all those unknowns are not in your favor. They should be held against you. What we don't know is, sort of goes to who has the burden. And I suspect you're going to tell me the burden flipped because it was on a motion for reconsideration.
I think that's one response, Your Honor. Yeah, yes, that at that point, because this really wasn't new information, and the judge had actually already considered it, he had no obligation to reconsider what he'd already said. So that's one answer. But even if Your Honor doesn't agree with that answer, we argue that he did meet his burden by presenting these studies showing why vaccination wouldn't be as effective for him in light of his severe risk factors due to the multiple severe medical conditions and due to his age.
In considering whether the statutory standard has been met by the evidence shown in this case, do you think that it's appropriate for this court, permissible for this court to consider what we know now about the vaccine's effectiveness as opposed to what was known then?
So I think in the normal course of events, Your Honor, you look at what the judge had in front of him when he was making the decision. And, Autry kind of indicated that in this fast changing, unpredictable pandemic, evidence can change quickly by the time it even gets to the appellate court. And that in abuse of discretion, you're saying, did the judge make the best decision he could at the time he made it, given the facts he had? We submit that he did. But if this court were to consider later evidence, one factor is that Mr. FACON is eligible for 3 boosters on account of his age and conditions and his incarcerated status, and the new CDC booster that was recently approved for the now dominant Omicron strain. He has received none.
Excuse me?
He's received no booster. And the CDC, as recently as last month, was warning that even people with 2 shots, the primary series, what he has, if they're old or if they have severe medical comorbidities, they're still very much at risk because the Omicron strain is now dominant. It's more transmissible and it's not.
Is that he's been offered no boosters?
He has asked for a booster and he has not received one. And the most recent information I have on that was Monday. He had not received one as of Monday. And the government has not offered any evidence that he has received a booster. So if the court were to look at what we now know, the court can find that it's true that vaccine immunity wanes after about 6 months. It's true that variants pop up that are more transmissible, that the vaccines are not tightly correlated to. And we presented the early studies indicating that that was the case, and the judge made a reasonable inference based on what he knew at the time he had it, that those studies helped buttress the severe risk factors that Mr. FACON had already presented and rebutted any government contention that once he was vaccinated, he was essentially ineligible for compassionate release on those grounds.
Now, Mr. FACON, a couple of years have gone by, I guess, as Mr. Gannon pointed out. Mr. Faison has not suffered any acute vulnerabilities, has he?
Do you mean has he gotten COVID, Your Honor?
Yeah, for example, or has it, well, or has he gotten COVID? And has COVID, and has COVID caused him any severe medical complications in that period of time?
To the best of my knowledge, he has not gotten COVID. Because he's in prison with the pandemic still ongoing, I believe when I last checked yesterday, the prison is now moved to level 2 as an indication of, it can be a number of factors. It can be vaccination status, COVID within the prison. But so when prisons are in level 2 or level 3, the highest one, the types of programming they can do are limited. They might not be able to go out of their cell as frequently. So he's still being very much affected by the pandemic, and the prison is taking steps to lessen transmission of COVID because prisoners are still highly at risk because of their incarcerated status. And
Could you speak to the other prong of this, whether the judge is finding that Mr. Faison had met his burden of showing that he is not a danger to the safety of any other person or the community?
Of course, Your Honor. We argue he appropriately exercised his discretion in determining that Mr. Faison does not pose a danger to the community. In more than 22.
What evidence is there that shows that he's not a danger to the community?
So, Your Honor, we presented evidence that's been about 10 years since his last disciplinary infraction. The most serious one was about 10 years ago. He has not had an infraction for contraband since 2004. And the trial court.
Why exactly does evidence that he hasn't had any disciplinary infractions for 10 years? Why does that indicate that someone like Mr. Faison is not, if he is released from jail, from prison, would not be a danger to the community?
Well, so a couple answers, Your Honor. One, 10 years is also 10 years in his age. And as we discussed in our brief, and as studies kind of pointed to in our brief, discussed that the risk of recidivism does decrease as someone ages.
Well, that's a general statistical phenomenon, but that can't be the basis for finding that this particular person will not be a danger. I mean, Mr. Faison's course of behavior in his entire life makes him look like a very dangerous human being. And I'm just wondering what evidence there actually is to support a finding that he met his burden of proof, that it is more likely than not that he will not endanger anyone.
Because as this court has found, the question is present and future dangerousness, not past. And so when you're looking at present and future dangerousness, the fact that it's been 10 years since he had a disciplinary infraction is very relevant. The fact that he has completed programming that place him in the top 12% of inmates in terms of completed programming is relevant.
What kind of programming is that?
So it's a variety.
What I do remember is that he declined or refused to accept sex offender programming.
So that is disputed, Your Honor. As we noted in our brief, Mr. Faison does not believe that he refused sex offender treatment. I agree the record has, a couple pages where there's a box checked indicating he refused it.
Well, did he come and testify and say, I actually didn't refuse it?
He has told us that he didn't. And what I can tell you, Your Honor, is that he wants to take part in sex offender treatment. And if he's released, he is perfectly willing and knows of all his obligations to register as a sex offender in both DC and Maryland, where he hopes to reside. And he wants to and will.
But the point, but regardless of what he says he wants to do, and maybe what he genuinely would do, he hasn't done it yet. So he hasn't had that treatment yet. So I'm wondering, what is the programming that he's had that is evidence that he would not be?
So a couple of answers, Your Honor. One, sex offender treatment in prison is not always, there aren't necessarily enough spots for everyone who wants to take it. So even if he had wanted to, he might not.
Prison is not an easy place to demonstrate that you are not going to be a danger to society. It just isn't. That's the situation he's in. But I'm asking, okay, that's just the way things are. What is the evidence that he can point to that he has had programming that makes him a less dangerous, not just makes him less dangerous, but that indicates that he will not be a danger to people. I mean, he spent years and years in prison on his previous conviction, and within 2 months of getting out, committed the crimes for which he is now in prison. And one could fairly ask, well, what proof do you have that you're not going to behave the way you've always behaved?
Well, again, Your Honor, we point to the length of time he's been in prison with the past 10 years having no disciplinary violations. The proof of his rehabilitation, that he's had no contraband violations. His ongoing strong
See,
support.
what bothers me is the notion that a person in prison whose life is regimented and who is carefully watched and so on and so forth doesn't have disciplinary problems strikes me as very insignificant when the question is, well, how is he going to behave when he's out of prison?
I take Your Honor's point. It's actually, I think, as other cases have made obvious, it's very difficult to not get disciplinary violations in prison. I mean, some of his violations are for as simple as refusing to follow instructions. So I think it is actually significant that it's
No,
been so
I
long.
take the point. All right.
But I also want to point to his strong relationship with his family, including his sister, Ms. Glover, who has offered to open her home to him, to have him live with her, to help take him to any treatment and counseling obligations. He's maintained gainful employment throughout his time in the prison system. He's a changed person. He's committed to being a productive member of society upon his release. And it's been, he's now been in prison more than
What's
twice.
the evidence that he's a changed person and committed? I mean, did people come in from prison, and say, I've been working with this person and he's a changed person for the following reasons? What is the evidence that he's a changed person?
Again, Your Honor, I point to the evidence we presented in Superior Court about his disciplinary history, his commitment to improving himself by completing all those programming courses, placing him in the top 12%. And it's difficult to maintain that type of strong tie with your family when you're in prison for over 22 years now. And so I think all of those are indications that he's just not the person that he once was.
The connection between having a strong family relationship, assuming that the evidence actually shows that, and not being a danger to the community, strikes me as elusive.
I understand your point. I think I'm pointing out that there are, unlike some offenders who might be released without a support system. And so, Your Honor, you pointed to, he's in this regimented system and he's done okay. So what's to say he'll be okay when he's out on the street? The answer is that he has a very strong support system when he's out on the street. He's going to be with the care of his family that he's maintained close ties with, and she's going to be there to help ensure that he's maintaining the discipline of going to those counseling appointments, taking sex offender treatment. So I think the strong ties to the family are, once you're out of prison, what's keeping you from becoming a danger? And that is one answer, Your Honor.
Before you sit down, could I ask you to quickly summarize the argument you make about the defects in the government's notice of appeal? I'm trying to call forth those arguments and I'm having some trouble.
Yes, Your Honor. So as this court knows, the government did not initially indicate that it was appealing the amended judgment and commitment order, which is what actually modifies the sentence. And we called attention to that as part of the motion to dismiss briefing. It is true that the rules have since been amended to say that you don't have to designate every single order to kind of perfect your appeal. But it's always at this court's discretion whether to kind of overlook those types of errors. And we would just point to this as a larger evidence of the government's not really sure how it can appeal this or what it even needs to specify to appeal.
What did the government specify as the order appealed?
I believe it was the reconsideration order issued in April 2021, and then the final judgment issued in August 2021. And it's kind of interesting that the government didn't notice the sentencing order, because it actually has this debate about the discrepancy between the sentencing order and the omnibus order in August. And as we've kind of discussed at length about jurisdiction, they're trying to change a sentence. And so it's actually pretty important that it's the sentence that would need to be vacated here if this court decides it has jurisdiction and wants to remand. And so we just think it's part of the atmosphere of the government doesn't have a right to appeal here. It wasn't really sure what it was appealing, how it was appealing it. And we think this all kind of hints to lack of jurisdiction for this court. And I did want to briefly discuss Your Honor's question about the D2 policy reasons. I think one reason that the council might want to grant the government a right to appeal in that instance and not here is that In D2, there's the concern about someone failing to appear for trial for sentence or appeal, and that's not as relevant here. And so there's kind of different government interests in D2 that are not as relevant in the compassionate release context. And another thing I'd point to in D2 is that, you know, we argue and PDS argue that that's really just for Chapter 13 bail release decisions. And I think one evidence for that is the structure of the statute that's in Title 23, whereas the compassionate release statute is in Title 24. And I can't really think of a good reason why, especially in this backdrop of government appeals in criminal cases being highly disfavored, that you would be able to take a decision made in Title 24 and go use a separate provision in Title 23 to appeal it.
You know-
Except the plain language, right?
Well, the plain language that, you know, as Peterson found, as PDS has cited, is actually analogous to federal statutes that do not give the government right to appeal this. And, you know, this court has said, even if the language appears to be clear, we will look at the legislative history. And I think the legislative history affirmatively establishes that it was meant purely to give the Attorney General the same right to appeal bail decisions the U.S. Attorney had.
I didn't see in the legislative history any specific discussion of the provision we're focused on. There was a discussion about some parity between the U.S. Attorney's Office and the Office of the Attorney General as to some of the other situations that are enumerated in the statute. But really an absence of discussion in the testimony by Mr. Spagnoletti and also in the committee report about this particular language.
My memory, Your Honor, was that there was some discussion about why this wasn't redundant with, I think it's 1324, which gives the U.S. Attorney the right to appeal release decisions. So my memory wasn't that it was discussed. But regardless, for the reasons in our brief in PDS, we do not believe that's a jurisdictional hook here. And unless there are further questions, I see that my time is up.
Counsel, thank you.
Thank you.
Mr. Linares, you asked for 4 minutes. We'll give you 5 minutes.
Thank you, Your Honor. I'd like to start with the pretty absurd argument that the government is at fault for not bringing Mr. Faison's vaccination status to the court's attention. The government filed its opposition to Mr. Faison's motion for compassionate release before he had been vaccinated. He subsequently received the first shot of the COVID-19 vaccine, and then he filed a pleading saying that when he would be vaccinated was unknown.
He filed a pleading, or his attorney filed a pleading?
His attorney, but we attribute facts to the client, not to the attorney.
That's true. I mean, but in fact, we also attribute knowledge to the government, though, when it's within the government's, sphere. Here, this is information that's at your fingertips as well. And as a practical matter, I think they've got a pretty good point, especially during the pandemic. I think getting a client on the phone, I don't know if you've ever, I'm sure you have at some point tried to get somebody on the phone from BOP. It can be a months-long process to do it. So it is, I mean, I take your point that the government was dealing with fast-moving information and that should not be held against you. I think it's a little bit of a reach to say, and it should be held against the defense attorney who really has no realistic way to keep up to date on these things. Even the letters take weeks to go through BOP. So, I think that's a little bit too far.
If that's what Your Honor thinks, that's fine. We're not nothing in our argument turns on holding this against Faison or his attorneys. We're simply pointing out that the government filed its pleading before he had been vaccinated. He was subsequently vaccinated. He never brought that to the court's attention, even though he in fact filed a pleading after he received the first shot. And so if we're looking at equities here or trying to balance equities for purposes of the motion for reconsideration, it's hard to see how the government could be at fault in this case for not bringing vaccination to the trial court's attention earlier.
What's the gap in time between the hearing and when the vaccination happened? Do you remember?
I don't believe there was a hearing, Your Honor.
It was rolled on the papers?
I believe so, Your Honor. Mr. Faison received the first shot on February 11th. 2021, his second dose on March 3rd, and the court issued its indicative ruling on March 8th, and the government moved for reconsideration, I believe the next day or within a day or two. In terms of the argument that we are, for mandamus purposes, we're evaluating sort of the set of facts before the trial court at the time it ruled, Banoff did not take that approach. This court in Banoff granted mandamus relief based upon new facts that arose just 2 weeks before oral argument. The court said, even if the trial judge had discretion to do what it did, in that case, require the attorney to continue representing the client, based on what happened 2 weeks before argument, the trial court no longer had that discretion and mandamus was appropriate.
On the question of jurisdiction, Mr. Gannon argued that there's no principal distinction between Rule 35B motions no principal distinction for that would justify not allowing the government to appeal a Rule 35B motion, a grant, and yet allowing the government to appeal a compassionate release motion. He's probably groaning now that I've misstated his position slightly, but I think that's the basic notion. Could you speak to that?
Yes, Your Honor. So the history of Rule 35 is that that sentencing orders were considered to be in the breast of the sentencing court for as long as the term of court continued. And so that a court could change its mind about the sentence for the entire term of court. So which as I understand it, is up to a year long. So Rule 35 was meant to codify and put some time limitations to that historic common law practice. And so it allowed a trial court within 120 days of sentencing and then appeal and then cert denial to reconsider its initial sentence. But so that makes clear, I think that history, the common law history makes clear that the Rule 35 judgment is part and parcel of the initial sentence. It was considered historically to be part of the initial sentence for the court to sort of sit and wait and decide what it ultimately wanted to do.
But do you agree with the point that during that Rule 35, and let's say it came after 120 days after the appeal, which might be several years, right? That the court can consider any intervening circumstances that it wants to? I mean, not that I don't mean like arbitrary things, things that are relevant to sentencing at that Rule 35 stage. The court can consider intervening circumstances.
Yes, Your Honor, I do agree with that. And I think this court in McBride suggested in some respects that the court, at least in some circumstances, must have intervening circumstances. So McBride dealt with a 11C1C plea to a fixed term. And then the defendant sought relief from that sentence under Rule 35. The court did not decide the issue, whether that was allowed or whether it was precluded either by the rules or contract principles, but it did rely on a Ninth Circuit case and others that suggested that if the court is allowed to modify the sentence under those circumstances, it must be in regard to new circumstances as opposed to. It must be in regard to new circumstances that arose after the initial sentencing, that the court wouldn't have authority under Rule 35 to modify a C1C sentence based on factors that existed at the time of sentencing. With regard to I would just point out that the Supreme Court in Dillon said that a sentencing modification proceeding is not a sentencing. The same rules that apply to sentencing, things like the defendant's presence, do not apply in the 3582 context in federal court, that's part of what the DC Circuit relied on in Long to say that the sentencing modification process is not an appeal from a sentence. It is a separate order, and that I think underscores the distinction. Reading of the evidence before the trial court, the evidence was much more tenuous about what things may affect people who have been vaccinated or what things may affect people with certain underlying conditions. But regardless, the trial court didn't rely on an Autry type finding that he nonetheless remains acutely vulnerable. Its reasoning itself was that the vaccine is not 100% effective and some risk may remain. And under an abuse of discretion standard, the parties are entitled to a ruling that is free from erroneous legal considerations. And so regardless of the evidence, which I disagree with their reading, the trial court's basis for its denial of the government's motion for reconsideration was directly rejected by Autry. And finally, as regards to dangerousness, the defense has routinely called our appeal on that ground half-hearted, but it's nothing of the sort for all of the reasons the court indicated, particularly Mr. Fasson's lack of sex offender treatment. Regardless of why that might not have happened, he attacked a woman at knife point, carjacked her and raped her, and has not received sex offender treatment. And he has had more than 2 decades to do it. So, that is one of many indications.
That's a very common thing that comes up oftentimes. What you hear the same thing from the defense. I don't know what's true and what's not, but there's not a lot of evidence in this case. Usually what you hear is they say, well, it wasn't on offer. And here what the government points to, as I understand the record, are 2 documents with a line that says, I think, sex offender treatment decline. I don't know who declined it. I don't know if they declined to offer it. I don't know if he declined it. And that strikes me as relevant. And I know the government has pitched it as he refused. And I just wonder if there's really a basis for us to say that. There's nobody who's offered testimony or an affidavit that said I offered him sex offender treatment and he didn't want it. Is there?
There's no such affidavit. But even if you don't think those records are sufficient to make a finding that he declined it, he has not received it. He does not dispute.
It's quite different though. It's quite different if it wasn't on offer.
I disagree.
It's harder to hold that against somebody. He might have done all he could in his own power, but that's kind of a BOP problem. If they don't think it's important enough to offer to people, I have a little bit of a hard time holding that against somebody.
I respectfully disagree, Your Honor. It's his burden to show non-dangerousness by preponderance of the evidence. He has not received sex offender treatment. He committed a horrific rape just 2 months after getting out of prison for 10 years. Many of the circumstances, his family ties, his supposed sobriety, his attending meetings and counseling for substance abuse problems were all true back then. And under these circumstances, the district court or the trial court, put far too much weight on factors such as age and current health that cannot bear the weight the trial court assigned, and particularly when the court found other factors to weigh so heavily in favor of continued dangerousness.
But does your argument amount to an invitation to us to reweigh the evidence?
It's not a invitation to reweigh the evidence, Your Honor. The Sixth Circuit in the Sweet case we cite, the DC Circuit and its recent decision in Catala have reviewed for highly discretionary decisions. Catala was a sentencing, and found an abuse of discretion when the trial court placed too much weight on some factors and too little on others. And so that's not a reweighing. It's an analysis of, under the trial court's own structure, can the factors that it said weigh in favor of release, given its own view of those factors, carry the weight that the trial court assigned them. And here, the trial court said, for all sorts of reasons, he's still dangerous. The nature of his underlying crime, his criminal history, the fact that 10 years in prison did so little to rehabilitate him in the past, said weigh heavily against release. And against that, it offered, as Judge Glickman pointed out, some period of time without disciplinary infractions, a limited amount of prison programming, but no sex offender treatment, and nothing that would outweigh those strong indications of his current and future dangerousness. Thank you, Your Honor.
Counsel, thank you all. The case is now submitted. Josh, do you wish to take a recess at all? Thank you. We'll call the second case on the calendar. District of Columbia versus Design Center Owner LLC.
Thank you, Your Honor. May it please the court, Ashwin Pathak for the District of Columbia, and I'd like to reserve 5 minutes for rebuttal. When buildings are transferred to new owners, transfer and recordation taxes are due on the consideration paid for that conveyance. Here, everybody agrees that the buildings were transferred from a set of companies under the umbrella of Vornado to brand new companies that never had any previous interest in these properties, WOC and Museum of the Bible. Nevertheless, these companies believe that they can avoid transfer and recordation taxes on that conveyance of buildings to brand new owners because they accomplished that conveyance through a mechanism of a ground lease termination. That cannot be right. It is not in accordance with the plain text of the statutes here, and it would also open up a massive loophole in this regime, which would allow any developer to avoid transfer and recordation taxes on the transfer of buildings to new owners, despite paying millions of dollars for that exchange. That is not what the council intended, and this court does not need to adopt that theory. And I'm happy to go through the reasons why the plain text of the statute applies clearly to this particular transaction. When you look at what happened here, on the same exact day, at the same time, as part of the same transaction, the parties executed special warranty deeds and ground lease terminations that had the effect of transferring not just the land, but also the buildings to brand new owners. And those new owners got those properties unencumbered by any other interest. So
I just want to break this down. I mean, you're speaking quite globally about the transaction. I just want to go a little bit more piecemeal through it, and I might do it with some hypotheticals. Let's take a different transaction. Let's say instead of buying the ground and I think importantly, the reversionary interest in the structure, all Hobby Lobby does is comes in and pays the sub for its ground lease, and so for its obligations and rights under the sub. So they're buying 17 years of the right to use that land. Do you think that would be taxable?
yes, and the reason is that if they're purchasing the ground lease here, under the terms of the ground lease, the buildings on the land are owned by the lessee. So they would also be purchasing buildings in that situation. And the ground lease plainly says that the fee simple interest of the buildings is owned by the lessee. And this makes sense in that situation. So in a situation where you're
I think that might be right, but I just want to, I mean, as I understand it, the district has never, so if that were true, then at the end of every ground lease that's structured like this, you ought to be taxing the transfer back to the property owner, right?
So I think that actually is the one exception where the district doesn't think that the tax would apply. And the reason for that is because this entire regime is based on the recordation of documents after they're executed. And so when you have the natural expiration of a ground lease, there is no additional document that's executed. There's no sort of change in the position of the parties. And therefore, there's no document that's going to be recorded with the district, and there's no tax that's paid. Now, I agree that may seem slightly anomalous, but I think this entire—
I mean, it doesn't make any sense to me at all. I mean, the original ground lease contains a reversionary right. Why isn't that the document that's the deed? Well, I mean, because it says that at the end of this 30 years, it's going to go back to the ground owner. So why at the termination of the 30 years, when that takes effect, we can talk about whether or not that interest is vested at the moment that it's entered into or not. There's a transfer back to the lessor. So I don't understand why that wouldn't be taxed under the plain language of the statute. So
the reason is because the plain language of the recordation requirement says that within 30 days after the execution of a deed or other document by which legal title to real property is transferred, you have to record it and then pay taxes on it. So if there's no actual execution of any document, you can't record it within 30 days of that time. And therefore, all of these tax provisions— I mean,
the document's been executed on day one, right? The document's been executed in 1981. It would be very hard to assess the tax on a reversionary interest that's 40 years in the future. But I don't know if the statute precludes the tax authority from waiting to see what that, or taking a best bet. I'm not sure. It is just I guess it strikes me that the way the statute is written considers ground leases in sort of the more common law form where the property and its improvements remain with the owner. And if that were true, so give me that same scenario with somebody trying to purchase the assignment to the ground lease, the 17-year ground lease here. So let's say, I can't keep all the parties straight, but the parent corporation owns the ground, and under the terms of the lease, they continue to own the improvements, but the sub has all the rights to use the property and the improvements for the 30-year term, or 50 years, I think here, something like that. And then 17 years left, Hobby Lobby goes to the sub and says, we want your ground lease rights. Here's a bunch of money. I assume you would say that should not be taxed.
Yes, that should not be taxed, assuming that there's no conveyance of buildings to new owners, which in that situation, there wouldn't be because the landowners own the buildings there. So all that would be transferred.
Kind of out of, because of this, what strikes me as, which I don't think is a point against you, but it strikes me as a very formalistic point of, in the way they structured the 1981 lease, they said title to the improvements is held by the lessee instead of the lessor, when in effect, there's no freaking difference between the two. Whether or not it's, and that's what's kind of catching me up. And so I sort of think, we shouldn't really treat those two situations differently. In either case, we should treat them like a ground lease. We know that the lessor is going to have a reversionary interest. They're going to get it all back later. And so unless it's more than 30 years, we don't want to tax that. If it's more, we want to tax that. And we should just kind of forget about this, where title lies, because title really is transferred to the lessee. I would think you tax it whenever, whatever existing structure transferred to them. And then I would think you tax it again when it goes back. Does that make sense?
Do you
think it's, I'm getting, because the execution business that you highlighted earlier is going to make it impossible to tax the later thing on the front end, that doesn't work.
I think that last thing you said is correct. And I think most of what you said is correct, actually. And so I agree with that, generally speaking. I think there is this quirk about the natural termination of a ground lease. Obviously, you're right that at the initiation of the ground lease, if that results in the transfer of buildings to the lessee under the terms of the ground lease, and they pay consideration for it, or there's, the fair market value of whatever those buildings that might pre-exist, there may be tax paid then. It's hard to know how exactly the agency would go about making sure that it taxes every natural expiration of a ground lease when there's no document that's filed. I mean, nothing happens in that situation. And this entire regime is based on recordation of documents with the agency. So I think that's the issue. And I actually don't think it should be that surprising that that's the case. In the vast majority of situations, when you get to the end of a decades-long ground lease, the buildings are unlikely to be worth much money at all. So in most situations, even if, and don't get me wrong, if the court wants to say that the natural expiration of ground leases also results in taxes applied, transfer and recordation taxes applied, I don't think the agency would be upset with that outcome. I just think it would be highly unadministrable. But in most situations, those buildings are unlikely to be worth a lot of money. So there's probably not going to be any tax owed anyway. And in a situation where, say, the buildings are worth a ton of money at the end of a decades-long ground lease, you can imagine that most parties are going to figure out a way to do something else other than just let the buildings that the lessees built and own revert to the original owners without them paying any consideration. There's going to be some additional deal between the parties that may well result in transfer and recordation taxes paid, or the lease just being extended longer.
You have a footnote in your brief that talks about the special warranty deed. And you note that the audit that pointed out the tax deficiency refers not only to the lease termination document or memorandum, but also it has the recorder of deeds number referring to the special warranty deeds. And you say something like the agency relied on the lease termination, but it could have relied on the special warranty deed as the taxable or as the document that gave rise to the transfer and recordation tax. And I have to say that sounded exactly right to me. And then I wondered why you put that in a footnote and why all of the argument seems to be about the lease termination. And I went back and looked at your opponent's brief, And I believe I could not find one mention of the special warranty deed. So explain to me why that got relegated to a footnote, because that strikes me as the taxable thing, for want of a better word.
Well, that's fair enough. And we certainly would be comfortable with this court saying as much. I think, so with regard to why it's in a footnote, much of our opening brief was responding to the arguments made by the Superior Court, and the Superior Court also never brought that up. But we did want to mention that, of course, in our notice of tax deficiency, we reference both documents. So the court is welcome to do so as well. Now, I actually think the best way to think about this transaction, and I think the reason that we really focused on the lease termination, is that it's sort of hard to think about what happened here without thinking about both the special warranty deeds and the lease terminations in combination, because they were really filed all at the same time. And if you just had a special warranty deed here that transferred the land to new owners, but you didn't have the lease termination involved as well, there would still be an encumbrance on the property, right? I mean, you would have lessee, the original subsidiaries of Vornado, the original lessees, would still have a leasehold interest in that property. And they really would technically also own the buildings in that situation. Now, this is kind of a strange case because the special warranty deeds claim that they're actually transferring the improvements also. But then you would have this leasehold interest that remains. And it's actually not quite clear how you would square that conflict.
Except that the parties acknowledge, your opponent's brief acknowledges that the purchasers paid for termination of the leases. Part of the deal was we're getting a termination. We're paying money for this. And in my mind, that equates to we're paying for the buildings because termination of the leases triggers the reversion to the lessor.
Absolutely. I mean, I think
So now my
right.
question is, did the district somehow forfeit this argument? I looked at the transcript of the hearing where this is discussed with the trial court. And the counsel says something there like, and maybe the point is even clearer there than it is in the footnote. We could have relied on the special warranty deed, but we relied on the lease termination memo. Is that an acknowledgement? Was that an acknowledgement that the agency rationale was X and therefore now we can't uphold what the agency did based on reason Y?
No, on the
Why
lease
not?
term, on the notices of tax deficiency, the agency clearly referenced both documents as the deeds that were underpaid in terms of taxes. So I think the agency offered exactly the justification that it needed to reference both documents and to have either document be the basis of not paying taxes. But I really do think that kind of differentiating between the special warranty deeds and the ground lease terminations here is kind of it's an artificial distinction because this transaction happened at the exact same time, and both of those documents were necessary parts of transferring the buildings to new owners.
Except going back to the prior example, and again, this kind of requires you again to just forget the lease term that title is in the lessees, and just assume it operates as a common law ground lease and title is in the lessors. Then it would seem to me, well, what they've purchased from the lessors would be the ground, and it would be the reversionary interest, which is an extremely important interest here because these properties are not going to be valueless after 17 years. But as for the encumbrance, the 17 years of it's just kind of a leasehold. I would think you would say, well, they can buy out that 17-year encumbrance, basically take on an assignment without being taxed because there's no transfer there. What they bought the rights to are the ground and the reversionary interest. But just as they could take out a 17-year lease, ground lease without being taxed under the statute, so too they could pay for an assignment of that lease under the statute without being taxed on that. I mean, do you agree if title were in lessors, they could do that? And that sort of 17-year encumbrance, if they were paying an actual fair market value for it, would not be taxable?
Yes, although I just want to be clear that what they would be paying, if the ownership is in the lessors, then it's not just a reversionary interest in the lessors. The lessors own the buildings in that situation, right? So the title is in the lessors. Right. They are buying the land and the buildings in that situation. And whatever consideration they pay for the land and the buildings, they need to pay taxes on. Then if they pay something more to the lessee in order for the lessee to agree to terminate their leasehold interest for 17 years, yes, we agree that would not be taxable. If it's more than 30 years, it would be taxable under the provisions that apply to leases for more than 30 years. So just to kind of finish up on the point about the special warranty deeds, I just do think that they're inextricably linked with the lease terminations here. But even if you look at the lease terminations on their own, even if the court decides that that is somehow forfeited along the way, the lease terminations here plainly are deeds, because explicit in the ground leases themselves is the provision that the lessee owns the buildings. So when you terminate that lease, you are necessarily transferring the buildings to brand new owners who never had any previous interest in the properties. And I think that's sort of a notable aspect of this case.
Well, I mean, maybe, but you say if they died a natural death, just a natural expiration, I'm still not sure why you think, but you say, that's not taxable. That's just very bizarre. I mean, you could imagine somebody coming in with 6 months before the lease's expiration and saying, here's $1,000 to get out 6 months early. And then everything's taxable. Whereas if they had just waited 6 months, none of the reversionary interest in the property would be. And that strikes me as quite strange.
It seems strange in the abstract, but I don't think it's actually strange in practice at all, because it would never be the case that lessees would allow extremely valuable buildings that they put up and they own to just naturally transfer to lessors, right? There would be some other, they would negotiate with the lessor, and there would be, because at the end of the day, if the lessee owns the buildings, they can just demolish the buildings, right?
No, that all makes sense.
So they have all the cards. So,
and I wonder if there is, I don't know if the district sort of raised, I mean, certainly not in the appeal, raised sort of an apportionment complaint. I mean, in fact, so far as I can tell, appellees, Hobby Lobby paid $0 for the reversionary interest in the structure. And when we're talking about a structure that they have valued at something north of $100 million, I forget exactly what it is, that is, obviously ludicrous. It is not the standard ground lease where that's going to be valueless at the end of the term. It is something that they've attained extremely valuable property right in the structure itself and paid $0 for it. But again, this is one of those, I've never really heard you say, they haven't paid for the reversionary interest. And I know, but you're making a larger umbrella argument. So it might fairly fit underneath it. But I guess I wonder why you're sort of, you kind of keep urging us to focus on this ground lease termination. For me, that's kind of buying the rights for 17 years to some of this stuff. Whereas the reversionary interest is in perpetuity, and it's kind of fallen out of the case in a way that I think might be a mistake.
Well, that's fair enough. I mean, I think going back to the hypothetical that you had suggested earlier about just the assignment of a lease that's 17 years, but where the buildings transfer as well to new owners, right? That would be a situation where, sure, there's a reversionary interest in the lessor, but we would still say that we tax the transfer of buildings to new owners if they pay consideration for them, and assuming the buildings are extraordinarily valuable, because the present fee simple interest is with the lessees. And just to go to your apportionment point, which I think is actually an important point, it would really be the other side's burden to somehow suggest, which they never have at any point in this litigation, that some portion of the amount of consideration that they paid went to not the land, not the buildings, but some other thing out there. Maybe it's the interest in just ending the lease, the possessory interest of the lessees.
Well, they say they paid for termination of the lease. That's what their brief says.
Right, but if you look at every aspect of this transaction otherwise, the $80 million of this $250 million is the land, right? Everybody agrees to that. So then the question is, what is that remaining amount of money? And the buildings, everybody agrees, are worth way more than the land here. On the office building property, there's a giant office building on it that's relatively new. So a huge amount of that remainder has to be for the buildings. There's no other explanation for what they're paying for. Now, it's possible, had they argued it in the Superior Court or before the agency, that some small portion of the $250 million actually went only to ending the leasehold interest, the possessory interest of the lessee, and not owning the buildings. They could have made that argument, but even that argument actually strikes me as a little bit absurd in this case, given all of the facts that we know now, that's because they are, of course, getting the 17-year remainder of the lease, the possessory interest, but they're losing out on 17 years of rent from the lessee. So, that's kind of a tit for tat. Now, maybe the rent is low or something like that, right? There's some additional amount, but you're talking a tiny, tiny portion of the $250 million that they paid. The vast majority of that has to be for the buildings, because all they were left with at the end of this case, at the end of this transaction, is land and buildings unencumbered. And so, I just note in their public offering, in their public statements about this deal, they actually offered these land and buildings for $260 million. So it's quite clear what they think these buildings are valued at. And when you look at the testimony of the buyers, what they specifically said was that they wanted the land and buildings on these properties in fee simple. So, that's what they paid for. That's what all the evidence suggests that they paid for. But, in another case, I don't think the agency would suggest that in another case, if a company's put forward some argument about apportionment, and that actually made sense based on the real value of the land and the buildings, that the agency wouldn't, take a close look at that and certainly acknowledge that. I'm happy to turn to the penalties question if the court has no further questions on the merits, although I know my time has expired as well.
Yeah, I was gonna say, but go ahead.
Just
We'll give you
briefly
a
on
couple minutes
the penalties question.
Can I lead with, it is tough to say, given the trial court's ruling, without saying, it's tough to say that what they did is wholly unreasonable when they've convinced at least one perfectly capable trial court judge that they were correct. Do you want to start there?
I'd be happy to start there. And two responses to that. The first is, there's no doubt the trial court disagreed with us on this question, but we're appealing that decision. And if we win on the merits, then it's pretty clear that the trial court was wrong. And I'd also note that the trial court, with due respect to the superior court, it really is very out of step with the vast majority of decisions in this area, whether it's this court's decisions in Cohen and Columbia Realty, whether it's a number of other recent superior court decisions that have broadly viewed the transfer and recordation tax provisions and have applied it in the case of mergers, in the case of transfers of ground leases that are over 30 years. So this is really an outlier decision in our view. But the second point I just make is, even if you think that somehow there was a reasonable minds could disagree on this question, they need to show that not only that reasonable minds could disagree on this question, but that they acted in good faith. And I don't think they acted in good faith here, because they neglected to inform the agency what they were doing, despite knowing that it would raise red flags. And the reason we know that they knew it would raise red flags is because they put in escrow the amount for the entire portion of the taxes, knowing that the district might challenge.
Yeah, they might challenge. I mean, that seems like the prudent thing to do, but the expression comes to mind, better to ask for forgiveness than for permission. It's generally not that people pre-clear their tax, things that they, I don't know, maybe you're going to tell me that it is. Maybe people ask for, I believe OTR issues advisory opinions and people can ask for them. But my guess is that the vast majority of things that skate up close to the line, people would rather fight it on the back end, or I guess that sometimes they pay under protest.
Well, yeah, I think that's right. And look, I mean, yes, if you are getting right up to the line and you don't want to tell the agency, I suppose you can try to get away with it, but you're also risking penalties in that situation. And
only if you're unreasonable though, right?
Or if you don't act in good faith.
And I think acting in good faith requires a sort of pre-clearance if you're getting up to dangerous territory.
Yes, if you're getting up to
what's your best authority for that?
I don't have a great authority for that, mostly because this penalty provision hasn't really come before this court all that often, because most people pay taxes under protest and then challenge it, usually because the issue is sort of fleshed out at the agency first. This was a situation where the FP7 forms that were filed here never mentioned that they weren't paying taxes on the portion of the consideration that they claim goes toward the buildings. And the way these FP7 forms—
Did they or did they not? I thought they filed their ground lease terminations in some way.
They did. They filed all of the documentation here, but just to sort of explain how the agency deals with these types of cases, the FP7 is really like a tax return, right? It's a document where you're supposed to sort of lay out everything that you've done and then say the amount of taxes you paid. And the agency just doesn't go behind the veil in most cases. They just look at what's presented to them. And if you say, well, we paid this amount of money and we're paying this amount of tax, that's sort of, the agency takes your word for it. And that's kind of how this entire the tax code kind of has to work because there are just too many transactions that, they're dealing with thousands of real estate transactions, hundreds of thousands of income tax returns. And you do sort of have to take people's word for it that they're going to kind of flag if there's a question, a borderline question, something that might raise red flags.
And to take that point, it strikes me that filing a ground lease termination, which I believe, if I'm not mistaken, did it state the consideration paid for that?
I don't know if I don't think the ground lease termination did, but in fairness to them, they also filed the purchase and sale agreements, I believe, in this case. I could be wrong about that, but I believe that those were filed with the agency. So if the agency had kind of really dug
the numbers seem staggering enough to not really, for the point that there's so much stuff to do, to land with me, where I would think these numbers are quite large. The discrepancy is quite big.
That's fair enough.
And I don't mean to say, definitely, I don't know, I'm sure there's a shortage of employees and it's tough to staff. So I don't know if somebody should have caught it. It does seem like they were doing less, it doesn't seem so hidden though. They are sort of flagging a little bit of it, maybe not as much as they should have.
That's fair enough. And look, the agency these days is looking at ground lease terminations much more closely because it is now aware of this, potential mechanism that some folks have used to try to avoid taxes. So this is just the first case that this ever came up. And it came up in a routine audit where the agency saw a $200 million purchase for buildings and $38 million were recorded as the amount that they paid tax on. And so that, they essentially got caught a few years later. And if this had all just been raised up front to the agency, like the vast majority of taxpayers do, and the final point I'll just make in response to the suggestion that you made earlier about, most people don't do that. I just don't agree with that. I mean, a lot of people ask advice from the agency. That's a huge part of their day-to-day work. And whether it's a formal opinion or more informal advice, they could have done that and they didn't. If there are no further questions, I will.
We'll give you a few minutes to rebuttal.
Thank you.
Good morning. May it please the court. My name is John Chamberlain. I'm counsel for the Design Center Appellees and the Office Center Appellees. These are the four entities who are the landlords and the tenants under the ground leases before the transaction at issue. Be sharing my time today with my colleague, Mr. Darrington, when we'll be splitting our time evenly. He represents the buyer entities. Your honors, there were two separate transactions here that have to be considered, two separate components to this transaction that have to be considered separately for tax purposes. Number one, the landlord transferred to the buyers its fee simple interest in the land subject to the ground lease. Consideration was paid for that, and tax was paid for that on the DC's own assessment of the value of that fee simple estate subject to the ground lease. Separately and apart from that, there was consideration paid to the lessees to terminate their ground lease, and that is not taxable under district law if the leases have fewer than 30 years remaining on their terms. I believe I just heard my colleague concede in his presentation that if there's a transfer of a ground lease with fewer than 30 years remaining, the transfer of the leasehold estate is not taxable as a deed.
Can I mention a third property interest that's at issue here, and it's the reversionary interest in the property? How much money did you pay for that? How much money was exchanged for the rights in perpetuity to the $100+ million building that is on the land after the termination of the ground lease?
That was captured in the consideration that was allocated to the landlord's fee simple estate. So the
assessment on the land alone. So $0.
The assessment, yes, Your Honor.
The answer is there is $0 paid for the reversionary interest in the structure.
That is not the case, Your Honor. Okay. When the district assesses the value of the landowner's fee simple estate subject to the reversion, it does take into consideration the landowner's reversionary rights. So when the taxpayers use the district's own assessment value for the land, they did price into that the value of the landowner's reversionary estate, over $30 million. It's not simply
for the land and the buildings, and the thing that was worth $150 million was the 17-year encumbrance on them.
Yes.
That doesn't strike you as mildly ridiculous? I know you're going to tell me, well, that's their assessment. And I'm going to tell you, well, their assessment wasn't taking into account the structures that were on the ground, even if they should have. That does not strike me as a fair market value. Like on its face, it seems laughably not. So I would love to know why you think that was a fair market value. I mean, please.
Your Honor, respectfully, the right to possess and use the property for a term of years, in this case, 17 years, is extremely valuable. And it is not at all uncommon. In fact, if you look at the assessments that are in the record, DC did separately assess the landlord's interest in the land and a separate value, which is greater, I believe, from my recollection, than the landlord's interest in the leasehold. They assessed the value for the landlord's interest and they assessed the value for the leasehold interest. And to the best of my recollection, the leasehold interest was valued as greater. So it is often the case, actually, and real estate appraisal practices back this up. If you have the present right to occupy the buildings for 20 years, to use them however you see fit, sublease them, build upon them, etc., that is actually worth more than the right to retake the land 20 years from now, often, as in this case.
Could you clarify something for me? In purchasing the leasehold interest from the lessee, I take it that the buyer also purchased the title to the improvements.
No, Your Honor, and just to clarify, the buyer in this instance did not actually purchase the leasehold estate. He paid consideration to have it. They paid consideration to have it terminated. But to turn to your question regarding title,
Maybe I phrased it wrong, but acquired title to the buildings.
so
To the
despite
improvements.
I know the district is making much of the fact that the leases purport to assign fee simple title to the improvements to the tenants. Those leases were actually drafted by the district itself when they were entered into the 1980s. And that was inartful language. There is no such thing as fee simple title that is subject to a reversion. Fee simple title means the right to own it for all time.
I thought that's fee simple absolute. I thought fee simple, you can have fee simple with the reversion, with the reversionary interest held in somebody else. I don't think that's right. I mean, the property treatises I've looked at tell me that you can do that, so long as it doesn't say fee simple absolute. That would be the contradiction.
Very good. Here. Whatever rights vest in the tenant in a leasehold, the right to possess it, whatever ownership interest it has in the land, those rights will be the same. Excuse me. The statute does not tax assignments of leases with terms of fewer than 30 years. That's common ground. Whatever transfer of rights occurs at the termination or assignment of a ground lease, they will always occur. This is not a special case. And the code specifically says that those sorts of transactions do not qualify as deeds and therefore are not taxable. So although I understand the court's concerns that the tenants had some sort of property interest right in the improvements, and at the end of the transaction, they did not and the buyers did. That's true. But we have a technical statute, and the technicalities of the statute have to be adhered to. And the statute says that, and the district concedes, that the transfer of a ground lease with a term of fewer than 30 years is not taxable, whatever rights accompany that.
And you seem to be equating that with the termination of a lease, and I'm confused about that. So maybe you can help me. The brief spent a lot of time talking about the fact that a transfer of a leasehold interest of fewer than 30 years is not taxable. And then it's pointed out that these leases had 17 years. And so they wouldn't be taxable, but there was, as I understand it, there was not a transfer of leasehold interest. There was just a termination of the lease, which seems like a different animal to me. Am I wrong about that?
No, Your
How's
Honor,
that
you're not wrong about that. You're correct.
Right, so.
The district the DC council has made a judgment. I apologize for interrupting.
Oh, that's all right.
Finished with your question?
No, I was just simply saying, at least to my understanding, the briefs seem to be treating the rule about leases for less than 30 years not being taxable upon transfer as leading to ergo the termination couldn't be taxable if it is part of this whole transaction, and if there is some deed that we can point to tax, and I just don't follow that argument.
Well, the fact of the matter is that the applicable provisions of the code say nothing about terminations.
Right.
And, but however, the district has conceded that in its view and in its interpretation of the statute, the termination and the transfer of a lease with a term of fewer than 30 years does not qualify as a deed. They conceded that to the district court below at oral argument, and they were emphatic about it. Transfers and terminations of leases with terms of fewer than 30 years are not taxable. And the Superior Court took them at their word and applied the text of the statute, which nowhere mentions terminations. It taxes documents reflecting acts of conveyance.
Well, whether they did or they didn't, I can't recall, but it seems to me that when you have a termination, when you pay for a termination, that is part of a larger transaction in which the result of that is that ownership of the buildings goes to the party that's acquiring the land, that it is hard to escape the conclusion that there was a taxable transfer of the buildings as the end result of it. What's wrong with that reasoning?
What's wrong with that reasoning is that the statute specifically prohibits the result. The statute specifically says that ground leases with terms of 30 years, fewer than 30 years remaining, do not qualify as deeds. And the district concedes if you
Right.
terminate a lease like that, then it's also not taxable. So
But
you could imagine
why isn't the reversionary interest taxable though? I mean, I think what you're telling me is typically, and I think you've said even in this case, maybe because it was inartful when the ground lease was drafted, typically these improvements are held by the lessor, by the property owner, or at least at common law they were, and kind of, if not in this case, it's all sort of messy. But if that were the case, well, then you would have had to buy out you would have been purchasing the property and the ground from the lessor. And the only reason that this ground lease termination meant that the structure transferred was because there was a reversionary right. And again, it strikes me that has not, no money changed hands for that reversionary interest. I know you're going to tell me that maybe it did. But that is a conveyance. Buying the reversionary right is a conveyance. You conveyed a property right. I assume you'll agree with that much.
I do agree with that.
And that's how the termination affected. That's how you come into possession of this new structure. That plus termination means you get it.
Yes, Your Honor, but the consideration was paid on the reversionary interest, and tax was paid on the full amount of consideration paid for the reversionary interest. It might help to think of this as two separate transactions between perhaps more arm's length parties. If the lessee and the landlord are completely separate entities not owned by the same company, the buyer could have arranged this as two separate transactions. First, it could have bought the fee simple interest from the landlord subject to reversion at an arm's length price. That would include whatever value in the reversion the landlord, the buyer, that assigns to that. Separately, after that, they have the problem of the ground lease. Perhaps they want to demolish the buildings. They want to do something with the buildings. They've already paid the landlord to have fee simple estate subject to a reversion, subject to the ground lease. Now they go and they pay the lessee to terminate the ground lease. That is not taxed.
In this hypothetical, as you've described it, let me just ask you, 2 days before the closing, if you went to the Recorder of Deeds office and looked to see who owned the building, what would you see?
Your Honor, I don't believe that the Recorder of Deeds separately tracks ownership
Who
of
tracks ownership?
buildings as apart from the land itself.
Recorder of Deeds. You could not find out by going to the Recorder of Deeds. who the owner is.
If you went to the Recorder of Deeds, what you would find is that the landlord owned the land.
You
and
find the
would find
documents, basically.
you would find a memorandum of lease notifying the public that a lease had been entered into. But I don't believe that the memorandum of lease that was recorded in this case, because the leases themselves typically are not recorded. You record a memorandum of lease to give notice to the world that there has been a shifting of property rights on the land. But I don't believe that it says
Who the owner?
Or to the effect that the tenant now owns any improvements that it hereafter erects on.
So
the
who
land.
was the owner of the building 2 days before the closing?
The ownership interests in the buildings were split, Your Honor. The landlord had fee simple ownership subject to the ground lease. And the tenant had a leasehold interest in the land and buildings, possessory interest, subject to reversion at the end of the,
But
basically in a state for years.
I thought the lessee had, by virtue of the ground lease, a specific provision in the ground lease, the lessee had title, ownership of the improvements for the life of the ground lease.
But not fee simple absolute
Well, fee
ownership.
simple is just a couple of words. Isn't ownership the real, what's the point of saying in the ground lease that the lessee has ownership of those improvements? I assume that means the lessee could sell the improvements to somebody. The lessee could destroy the improvements if it was of a mind to destroy them. The lessee was the owner. Isn't that what the ground lease gave, or am I misunderstanding this?
I don't know why the parties, when they executed the ground lease in 1981, they were drafted by parties who are not present other than the district, who was a party to the original ground lease.
Yes, I understand. So,
But it is, I believe, standard procedure for a ground lease to include language such as that assigning.
well, that may be,
title.
I'm trying to determine what it means. I had been under the impression, maybe I've just misunderstood the case, that what it means is that for the life of the ground lease, the lessee has the rights that are typically understood to be the rights of ownership. And all that the lessor has is the hope and expectation, right, to get those rights back at the end of the ground lease. It's like, is that not the correct understanding of what we're dealing with here?
That may be the case. I would phrase it differently as the tenant having an estate for years in the building.
Well, the
But
reason I'm phrasing it this way is because I have the impression that even in the hypothetical sort of disaggregated example that you gave, what we have is in two stages perhaps, but what we have is a transfer of ownership of that building for which the purchaser paid. And we have documentation of that transfer of ownership of that building to the purchaser and that documentation meets the definition of a deed for purposes of the act. So it seems like if that understanding is correct, I have trouble understanding why recordation and transfer taxes are not owed based on the acquisition of ownership, full ownership, fee simple absolute ownership, in fact, by the purchaser.
The reason is this.
Over a 2-day period or over a 6-month period, whatever it may be. And regardless of whether these things are done in coordinated or not fashion.
The reason is this, Your Honor. Regardless of how we characterize whatever property interest the tenant had in the improvements, even if it was ownership, whatever that means. The DC Council has made a policy judgment. These sort of policy judgments always involve line drawing, picking winners and losers. The council passes a statute under which this particular set of transactions are taxable, this particular set are not. When a lease with a term of fewer than 30 years is assigned or terminated, it will always result in the landlord having full ownership of the building.
See, I had understood that to mean, tell me if I'm wrong about this, or maybe I had reason to myself rather than understood. I had understood that to mean that if you just have a lease, you are the lessee of this property for 30 years or more, or less. Then that lease does not constitute a change of ownership triggering transfer taxes. And when you get it back at the end, it won't trigger a transfer of ownership requiring the payment of taxes. But here we have something more apparently than just a lease for less than 30 years. we have a lease for less than 30 years, and we also have an agreement, a provision that says ownership has been transferred temporarily, maybe for the 17 years of the lease. And I don't understand why we should think that the statute you rely on applies not only to the lease part, but also to the temporary or interim transfer of ownership part. Now, I grant you, it's a little hard to understand what exactly was meant by the transfer of ownership. But the natural understanding is, well, the transferee gets to do with that property whatever an owner can do with it, whether the lessor likes it or not. The improvements of that is what I'm talking about, of course. So that's how I've understood this, and that's how I've thought to myself that the statute you rely on doesn't really resolve this case. What am I missing?
Your Honor, again, this sort of shifting of property interests, however we characterize it, at the end of a ground lease, whether it is assigned or it expires or is terminated, will always move those rights about. Whatever rights exist in that ground lease, they will always move from one person to another when those sorts of events occur. What we have is a statute that explicitly says the word deed shall not include a lease for a term that is less than 30 years. It is a legislative command. It may appear.
So you think my rationale, my interpretation of that as not applying to a provision that transfers ownership.
Because under your
is incorrect if the provision is in the lease.
Your Honor, what I'm saying is that if we accept the district court, the district's argument in this case, every single ground lease, regardless of its terms, is subject to taxation. Because the sort of shifting of property interests, which has you concerned, will always occur at the end of a lease. Now, I'd just like to point out, it's undisputed that a ground lease termination has never been taxed.
Well,
before.
but let me just interrupt you because, I mean, I see this all the time. I have a condominium apartment, and in my building, the owners of the condominium often lease the unit to somebody. Well, the lessee in that situation doesn't have an ownership interest in the unit, even a temporary ownership interest. And so it's not true that every lease of property is going to give rise to the situation we have here. It's just what gives rise to the situation, seems to me, is this provision that may or may not be in lots of ground leases, I don't know. That purports to transfer ownership to the lessee for the period of the lease.
I'll make one more point
That's
in response to that, Your
uh,
Honor.
Go ahead.
There are three, as we outlined in the brief.
Excuse me?
As we outlined in our brief, there has never been a tax of a ground lease termination in the district before. The record includes 3 ground lease terminations in favor of the district as landlord. Each of those, and these are in the appendix at 133, 142, and 151.
And you might know off the top of your head, did any of those vest title in the lessee during the term of the lease?
That was my next point. The leases themselves are not in the record because they weren't recorded, and I don't believe the district produced them to us in this case in response to our request for documents. But what the termination memoranda that are in the record recite is that the tenant grants, conveys, releases, remises, and assigns its rights in the improvements to the district. Each of the 3 lease termination memoranda state that, and each was not taxed. Because up until this case, everybody agreed that the termination of including the district, everyone agreed that the termination of a ground lease is not a deed, giving right to recordation and transfer tax.
But I assume that's because the lessor held the improvements the whole time. I mean, you can think of a lease as an encumbrance, right? It is somebody else has a right to the property and the structure that you own, and the lessor is really the one who holds it the whole time. So when they're going to sell it to somebody else, they don't get to just sell the ground. They're going to need to sell the structure as well, subject to an encumbrance And then maybe, I think you have a good point, that maybe purchasing the right to that encumbrance should not be taxed in the same way that entering into a less than 30-year ground lease should not be taxed. Although it's a little bit bizarre here, because as your opponent says, it's really tit for tat. You haven't just given up your rights to the ground lease, you've given up your rights to collect from the ground lease, and so it starts to look like a little bit of an artifice. So if the cases aren't where title was vested in the lessee, then it just strikes me as totally unsurprising because there was no transfer in those cases. And here, you seem to, at one point saying, well, title wasn't really in the lessee, on one hand is what you say, but then kind of out of the next breath, but the lessor didn't really own the buildings either. And it's got to be one or the other. And which one is it? I know they each have some interest, but all the interests were transferred. So through a two-step process. And I don't think you can kind of have your cake and eat it too on this and say, on the one hand, they didn't own it. On the other hand, they didn't own it. It transferred by virtue of the great invisible hand.
Respectfully, Your Honor, that's not our argument. We
Okay.
acknowledge that there were two separate estates at issue here and that they were transferred separately and they each have separate value. Our argument is simply that the transfer of that second estate, or the termination rather, of the leasehold estates is not a taxable event, and that's supported by the clear text of the code. There's no distinction in the code
When you
between.
filed and I forget the number of the form, did you say what we're paying for is the ground and our interest and our reversionary interest in the buildings?
I'm
And
sorry.
that's when you sort of apportioned the amount that you'd be paying, both in the contract and when you filed your form with OTR. Did you say, look, this $38 million is for the ground and the reversionary interest in the buildings, and this $150 million is just for the 17-year encumbrance on the buildings? Or did you just ignore the reversionary interest entirely when you entered that contract and you filled your tax forms with the district?
The tax form that was filed with the district for the transfer of the title to the land by the landowner recited that it was for the transfer of fee simple subject to ground lease. It didn't use the word reversion. That was obviously implied. It's subject to a ground lease. There is.
So it's not implied if the lessor holds the property the whole time. I mean, if you're only talking about the ground and you're not talking about the structure that's on it, maybe I'm missing. Maybe we're talking past each other, and I don't want to hold you up on the point. I'll let you get to your. I'll let you get to your own points. I think I've drilled this into the ground enough.
Well, Your Honors, I see I'm out of time, and I do want to have respect for my colleagues' time.
Thank you. And we'll give you a minute or two in rebuttal if you'd like to.
I'm
take
sorry.
it. We will give you a minute or two in rebuttal if you'd like to take it.
Thank you, Your Honor. I would like that.
Good morning, Your Honors, and may it please the court, Mike Dearington on behalf of the Museum of the Bible and WOC LLC. I'd also like to reserve 1 minute of time if that's amenable to the court for rebuttal.
I misspoke, didn't I?
If you were going to offer a rebuttal, I was going to take it.
This is why senior status is looming for.
I liked the new policy as I thought it to be, for what it's worth. So my argument today was meant to focus on why the Superior Court's decision granting summary judgment in favor of the petitioners is compelled by the plain and unambiguous text of the transfer and recordation tax statutes. But given many of the court's areas of inquiry, I'd like to start by responding to certain of the points made by my friend from the district, as well as some of the questions posed to my colleague. So the first 2 points I would like to make regard what the actual issue presented here is and the related question of waiver, and then another area of inquiry which relates to what exact interests were in play here before and after the multiple transactions. And I think I'm going to start with the latter point, which is that, as Your Honor, Judge Deal mentioned, it is Your Honor's view that there was fee simple title, I believe you said, in the lessee by virtue of the ground lease document. And we would vigorously disagree with that. Now, I take Your Honor to mean, and I'm sure you'll correct me if I'm mistaken, that fee simple of some kind, whether it's subject to termination or expiration, according to Your Honor, was granted in the ground lease. But that's not the same thing as fee simple title or ownership. Ownership is permanent. ownership, according to even Black's law, means that you have permanent custody, possession, and control of the property. Ownership does not end on a particular date, or in Judge Glickman's experience, if you have a condominium, and even if that condo lease agreement states that the lessee will have fee simple of some kind in the apartment, none are to believe that the lessee owns that apartment. In fact, in this circumstance, the lessee has to pay ground rent, which is something that doesn't happen when you own something. The lessee has to maintain the buildings, something that is not required of someone who's a true owner. And the lessee is not able to take there are certain other covenants that are incumbent upon the lessee in order to operate within the compliance of the ground lease itself.
So the lessor owns the improvements.
Well, Your Honor, it's not quite so simple. And I'll put it as
One
simply
of
as I
them's
can.
got to own it.
Your Honor, I think that may actually oversimplify the condition of the property and the rights at issue before these transactions. So the lessor had a ownership interest, fee simple title in the land subject to the ground lease, which meant it had a reversionary future interest in the buildings. Your Honor pointed out that perhaps the amount paid in tax, or suggested that perhaps the amount paid in tax for the sale of the land subject to the ground lease, which included a reversionary interest, should have been higher. And that goes to my first point, which is the district has never made that argument. We've been at this for 4 years with the district, and this is the first time I've seen the district point or pivot to that new argument that has been waived time and time and time again.
Well,
and I'll walk you through.
Their argument all along has been, you got the land, you got the buildings, you better pay taxes on the land and the buildings. The particular nuances in terms of, is that the reversionary right that you're paying for? I think the response is, well, that's kind of all on you to apportion. Like, that's not their business to apportion. All they know is they have this big chunk of money, I don't know, 200 some odd $1 million, and then a transfer of land and buildings. So pay taxes on the whole thing. There's really nothing else that was consideration was paid for, except for terminating a 17-year encumbrance. Is one view of it, and they say, well, that's all tit for tat because you're on both sides of that encumbrance. The parties are both lessor and lessee, and so that's kind of marginal. And how could that be the thing that's worth the $150 million when all the other rights are worth 38? They're making arguments like it. I'll say that. I take your point that they don't really identify it the way I think about it, but I don't ask parties to read my mind usually. They've gotten close enough.
Well, Your Honor, I would respectfully disagree with that entirely. In fact, my friend cited to the tax deficiency notice and said it referenced a deed. And I'm happy to quote from the tax deficiency notice, because what it said was that there is a tax effectively.
It's in the numbers, right? Up at the top, the numbers reference have document numbers that are both the special warranty deed and are the lease termination.
I take that to be what the district's point may be, that there was some number that referenced a deed, but in fact, the entire pros, and if we're talking about notice here, which is largely what waiver is about, giving us the opportunity 4 years ago to counter their arguments rather than wait till oral argument 4 years later. If we're talking about notice, if Your Honors read that notice, which is effectively what it is, it says we're taxing you on the ground lease termination. And that's been true in the district's answer to the petitioners.
Can you just remind me where in the joint appendix that my memory of that, which I've read, was that they were taxing you on the whole transaction. But there might be, both of those things might exist. And do you have a JA site for me?
I believe it's
Design Center.
1091, but
All right.
been mistaken before.
I see 1073. Maybe it's in that area.
There
Okay.
should be two, I believe.
Mhm.
And the one at JA 1091 that I see, sorry. Let me go back a page. At 1089 that I see says, the terminations of the ground leases at issue come within the scope of the district's recordation and transfer tax laws, and so are taxable. So the notion that the district can, based on the line of questioning presented by Your Honors and a footnote aside in I think, reply brief, I could be mistaken about which brief it was, suddenly pivot.
The footnote is in their opening brief, and then they expand upon it in page 7. And you guys don't mention it in your brief. And I understand it's tough to tackle everything that's in a footnote. Please.
Sorry, Your Honor. So if you think back to where we're coming from and the arguments that we're making on behalf of our clients, we start with a petition. The district answers. There's no reference to the apportionment could be wrong here. We engage in lengthy discovery. The district does not pursue that line of discovery, and so we are not in a position to pursue it either. The district then moves for summary judgment, and so too do we. And neither side, particularly the district, does not raise this apportionment issue. We proceed to oral argument. The district, again, does not raise this issue. And mind you, as a footnote, Your Honors, the district acknowledged during that oral argument that title ownership of the buildings was not conveyed by virtue of the ground lease, but that is an aside. During oral argument, the district does not raise this apportionment argument. When the parties were submitting a draft opinion reflecting the court's statements during the oral argument, the district did not raise this argument. And then in their briefs, it's this glancing aside, well, maybe if Your Honors will pick this other argument, since we've been losing on this argument that ground lease terminations are taxable, perhaps then we could have an apportionment issue. And that's not even to mention the fact that there's a statute of limitations issue here. So now 10 years later, it's a bit late for the district to be changing its entire theory of what should be taxed. So we respectfully—
Just reading from the notice, it is clear from the statutory analysis above that the conveyance of a building is a taxable event, regardless of the label of the document under which the conveyance is effective. Now, I take your point. It seems to be that they're highlighting the lease termination primarily. But another point is, what they're really saying is, look at the substance of this. This has been a transfer of the building, and you haven't paid taxes on it. I think that's fairly incorporated in that sentence that would provide you notice. I think that's fairly incorporated with the arguments they made before the trial court. And it seems that you're sort of faulting them. They've preserved their claim that you owe taxes on this transfer. They just haven't made quite the precise argument, the one that I have in my head. And I don't, there's a lot of our cases that discuss the difference between preserving a claim and preserving an argument. And you only need to do the first thing. You don't always need to do the second thing. And so I wonder if why we can't fairly consider it. I mean, all along, everybody's known what this has been about. It's just kind of what hole you cram it into, and that doesn't strike me as a notice issue. But
well, respectfully, again, Your Honor, we disagree. We think that actually the district neither preserved the claim nor the argument. And I believe Your Honor would know better than I, but I believe an argument can be waived. If an argument is not presented at the appropriate time, such that we're able to address the argument and counter it, I think that amounts to, as Judge Thompson said, a forfeiture of some kind. And we would go further and say it's in fact intentional waiver. They selected a particular document and they claimed that that is a deed. And that document happened to be a ground lease termination, despite that never in the history of the District of Columbia has the district said before that a ground lease termination is a deed, despite that the recorder of deeds was not even herself confident that a ground lease termination was a deed and said reasonable minds could disagree about this.
But there was this special warranty deed, which your brief never mentions. Does it have no significance? The special warranty deeds?
Well, Judge Thompson, I think you've captured this issue of waiver because the district itself.
Well, let's put aside waiver and forfeiture. I suggested forfeiture, but I'm not there yet. But I do want to know what you think the significance of the special warranty deeds is, because we have deeds that convey the land and the improvements thereon. And it is filed on the day of closing as part of the whole transaction, which also included as one of its elements, a payment by the purchasers for termination of the lease, which led to ownership of the land being in the hands, ownership of the buildings belonging to the sellers. And who conveyed that by special warranty deed to the purchasers. So, when we're talking about whether there was a taxable instrument transaction here, I just don't see how you ignore the special warranty deed, and yet your brief does, and I need to understand why.
Sure, Your Honor. So if the district had challenged the apportionment, that would have gone to the specialty warranty.
Well, I don't know that it necessarily gets to apportionment. I understand what apportionment is and what role it could play. It could change the amount of the tax, but the basic argument here is that no tax was paid on the transfer of the buildings, on the improvements. Tax should have been paid. Your position is no. There's the rule about leases for a period of time less than 30 years not being taxable. I'm not understanding why termination is subject to that rule. That's not a transfer of a lease, it's a termination, but that's a separate argument. But but my point is, my issue here is not apportionment. I don't know what the tax should be, but it just seems like the special warranty deed gave rise to a tax because it conveyed the improvements. So I don't know how it gets ignored. You seem to have a reason, and I just want to understand.
So, Your Honor, the specialty warranty deed conveyed what the lessor owned. And so that is the land with a future reversionary interest in the buildings. And that's the
improvements,
most.
it says improvements. The deeds say that.
Your Honor,
Am I wrong about that? I think they say land and improvements.
I'd like to just make sure that I'm quoting properly. So it says, together with all improvements situated thereon and all rights, titles, and interests appurtenant thereto. So the most that the lessors could convey as their interest in the improvements is the future reversionary interest in those improvements. And the most that the lessees could give up upon returning the keys upon the termination of the ground leases is a possessory interest. It's not an ownership interest. So
because nobody holds an ownership interest.
well, Your Honor, there's a bundle of rights in property law.
Right.
We all learn early on in law school, and that can be divided. And so the ownership interest is perhaps closest to, I don't want to frame it in the wrong way. The lessors own the land and they own a future reversionary interest in the buildings, and the possessory interest is in the lessee. And just like a tenant in a condominium complex, on the expiration or termination of the lease, the tenant takes the keys and brings them back. The fact that a signature took place because it was a year or 2 or 17 years earlier than the end of the ground lease is not what makes a deed. A signature does not make a deed.
Well,
A transfer.
It seems like if you have that bundle of sticks, and two people divide up the bundle of sticks, and one person has, the sticks over a certain length, and the other person has the sticks under a certain length, and they jointly enter into a transaction where they give all the sticks to a third person. You would think that that's sufficient to treat the transaction as deeding the entire bundle of sticks to the third person, would you not?
I would not, Your Honor, for the same reason that any tenant who hands the keys back at the end of a 1-year lease or a 30-year lease has not transferred a property interest
Well,
back.
suppose the tenant was allowed to put in a new kitchen. I hate to make this in such simple terms, simplistic terms, but put a new kitchen, and the agreement with the landlord was with the owner of the condo, in other words, was, well, the tenant can own that kitchen during the life of the lease. The tenant will be responsible for taking care of it, and the tenant can destroy it if the tenant so wishes. If the tenant really likes that dishwasher, the tenant can take the dishwasher when the tenant leaves, whatever. And at the end, there's a transaction in which the tenant says, I'm giving it all to you. I'm leaving and I'm not taking any of it with me. And we have a provision in our agreement that says you get it all. Well, why isn't that a transfer of ownership subject to, if the tax applied to this, recordation and transfer taxes?
Your Honor, it's a good question, and I think it gets at the heart of this matter, which I'll get to in a moment, which is that the very interest that you're talking about, Your Honor, is created at the moment that the lease agreement is generated. And at that moment, Judge Deal, I think, touched on this at the beginning of the argument in some way. In 1981, that was the moment when the district could reap its taxes, when a ground lease was entered into that was more than 30 years. But for one thing.
There were no improvements then. The improvements came later. Right?
Well, Your Honor, it wouldn't matter because the interest vests according to the case law in 1981. And there was only one reason the district didn't get its tax back in 1981. And that's because the DC Council spoke in 2001 in the Tax Clarity Act and said that ground leases of 30 and fewer years are not to be taxed when they're transferred or assigned. That's the only reason I believe that this was not taxed back in 1981.
But what happened here was there was an agreement between the parties involved that the leases would be terminated. your clients paid for termination of the leases. That was something valuable to them to terminate them. And I don't know, do we have to get into the order of operations here? But that happened, this agreement happened and was memorialized. And at closing, what then happened is that the leases had been terminated. The sellers now owned everything, land and improvements, buildings, and they transferred it all to the purchasers. And so that, it seems, is what's taxable. So we're not talking about trying to tax something that occurred in the past many years ago. We're talking about a special warranty deed that conveyed all the things that the owner or that the seller now owned, but has just transferred to the purchasers.
Well, Your Honor, what I was addressing about 1981 was in response to Judge Glicksman's question, when should this be taxed? Because we all feel like there should be a tax on this at some point, is the sense I'm getting from the court. But as to the question about the appearance of the transaction, that's exactly what this court in Cowan and Columbia Realty said we should not do, is look at the mere appearance of the transaction, which is what the district insists Your Honor should do. In fact, you have to look at the actual substance of the transaction. And here, the form and substance, and I like from an earlier argument that there was apparently a Carroll case that said form is substance in that particular case. I think that applies here. The form and substance of the transaction must be acknowledged by a court, must be acknowledged by the district. We can't say that there were sellers and buyers and ignore the fact that there was a lessor entity, there was a lessee entity, and then there were different entities for buyers. That's something that happened and it relates to the substance of the transaction. So we can't just look at what happened and look at the end result and say, let's tax the end result.
But in the end, form and substance kind of came together because there were special warranty deeds. All this other stuff happened. And then at closing, the kind of last thing that happened is that special warranty deeds were signed conveying land and improvements. And why isn't that the taxable thing that occurred?
Your Honor, taxes were paid on the specialty warranty deed, and I understand
part of the transfer, but not on the building.
No, Your Honor, on the interest in the building, all the interest in the building that the lessor had, a tax was paid on it. And I take Judge Deal's argument that the tax was not enough, but that ship has frankly sailed. But the tax was paid, and a special warranty deed is different than a deed. It's special because there's often going to be some encumbrance on the property. It's basically a way of the seller saying, I'm going to sell you what I have. I'm not going to tell you that there's not an encumbrance on this because as all knew, and as the district knew upon the payment of the tax on the specialty warranty deed, there was an encumbrance, and a valuable encumbrance to the lessee. So the specialty warranty deed is what the tax was paid properly on, and that encompassed the reversionary future interest. The fact that the lessee then was paid to get out of its lease early and just dropped the keys off 17 years early does not make it such that the lessee transferred an interest. It merely gave up its possessory right, just like any tenant would give up a possessory right at the end of the lease. And Judge Thompson, you made a point earlier that I want to make sure that I touch on, which is that you noted the possibility that a termination is not the same as a transfer. And I think the argument went that the exclusion from taxability as a deed of a termination, if it has under 30 years, is not so, even if an assignment of a lease with the remaining term under 30 years is not taxable, I think was your argument's point. And that actually explains why this transaction is not taxable, because the district conceded and acknowledged below, and while it's distancing itself from that concession now, it doesn't provide a valid argument or a colorable argument why the concession was not right. But the district conceded that if the lessee had merely assigned its interest to the lessor at the time of the transaction, there would be no tax. That's game, set, match. If we're talking about the appearance of the transaction, the district said you had a way of structuring this transaction where we wouldn't have levied a tax. And because you structured it this way, which we've also never levied a tax related to, we're going to tax you. And so from a standpoint of treating taxpayers the same, Judge Thompson, I'd like to carry that point into an illustration. Let's say that the buyers in this case had bought fee simple title to the land subject to the encumbrance of the grounds, just like they did. But they chose not to go another step and pay the lessee for early termination. So now they're just the landlord with a future reversionary interest. Another buyer comes along another tenant comes along and says, I'd like an assignment for your 17-year ground rent. And so the lessee assigns that 17-year ground rent. None would say that that assignment is taxable. But suddenly it's the same buyer who's now the landlord who walks into this transaction and asks for the very same assignment. And the district says, no, we're going to treat you differently because you happen to be a landlord and we're going to tax it. The tax code does not allow for that type of disparate treatment, Your Honors.
So as I listen to this, it strikes me that ultimately your argument is that the district sort of picked the wrong battle. The district should have, if the district thought that there was a valuation problem here, it should have said, well, the amount paid for the special warranty deed was really a sham. I'll use the word, I'm not really accusing anyone of anything, but just
Understood.
for a word, was really too low. Because really, and the amount allocated to the lease termination was really too high, in effect. The district's position is really, you should have allocated much more. This seems to be the logical consequence of your argument. The district's position should be, and they might be right, they might be wrong. You should have allocated more to the ground lease, to the special warranty deed, and less to the termination of the ground lease. Have I captured something in saying that in what you're as the logical consequence of your argument?
I'll put it this way, Your Honors. It seems clear that if Your Honors worked for the district and were at OTR, you might have assessed a tax by arguing that the apportionment between the non-taxable ground lease termination and the taxable specialty warranty deed was such that the specialty warranty deed required an assessment. That may be your position if you worked at OTR. I'm not here to tell.
Make that argument. Right, they didn't make that argument.
I'm not here to tell them what they should have done. I'm here to tell them, and Your Honors, our position that what they did do is they sought to tax an untaxable ground lease termination that the DC Council has expressly said is not taxable because the remaining term was under 30 years.
Yes, but that's a transfer, not a termination. That's the point I keep
Well,
coming back to.
Your Honor,
And no one has explained to my satisfaction.
So Your Honor, I'll take that proposition and I'll run with it. So if Your Honor's position is that there was a transfer here, well, that's exactly, I think,
Now,
what.
my proposition is there was a termination, not a transfer.
But isn't it so that I think Judge Deal at least has said that because if we're going to take the district at their word on appeal, which they did not make the point below, they took the opposite point. But if we take the district at their word that fee simple or fee simple title transferred to the lessees and then transferred back, and that's taxable, then we're treating it as a transfer. Okay, let's take for example, the premise that ground lease termination is a transfer because Judge Deal's point that perhaps a fee simple was shifted during ground lease when the ground lease was created in 1981 and it went to the lessees such that a termination created a transfer of rights back. If Your Honor is going to treat that as a transfer, as it must if it's going to say it's taxable, because the tax statute only includes the word transfer and does not say termination, then we're shifting to argument 2, which is another independent reason for non-taxability, which is that we have in order to tax it, it has to be a transfer, conveyance, or grant. So if it's a transfer, conveyance, or grant, step 2 is it has to have a term of over 30 years to be taxable. And that's where the district fails yet again. So there's 2 arguments here, each of which is an independent reason why a ground lease termination is not taxable. The first, under expressio unius canon of construction, is that there is no word terminate in a long list of actions that could signify a deed that is taxable. You have words like vest, grant, convey, sell, bargain. There is no word terminate. And adding to that, the noceteras sociis canon would suggest that any sort of act in order to fit within the scope of that statutory provision must be akin to a transfer, a conveyance, a grant, not the opposite, which is a termination. But let's say that this is a transfer we're talking about. The ground lease termination transfers ownership rights in the buildings back. The statute has a second part that says a deed excludes anything, any transfer of a ground rent that is under 30 years. And it is indisputable that the ground rent here is at 17 years remaining on it. So if the district wants to argue a transfer happened, how does it respond to the argument that that transfer only transferred a term that was 17 years and then runs into a second roadblock to taxation? And your honors, I'd like to overlay this whole discussion with the reality that Acme and Expedia say that if the tax statutes are not clear, the tax statute must be read in favor of the taxpayer. So I think it's fair to say that given this debate, it's not clear at a very minimum that this tax statute can tax a ground lease termination that is under 30 years in term. And we would submit it's in fact clear that the tax statutes do not tax such a ground lease termination. Unless your honors have any further questions, we'll rest on our papers and argument, and I guess without rebuttal. Thank you, your honors.
Just a few quick points in rebuttal, and I'm happy to answer any of your honor's questions. The first is, I just want to sort of back up and make a point about kind of there's been a lot of discussion about the difference between a reversionary interest, the fee simple interest that the lessees have versus the reversionary interest that the lessors have. And I just want to make clear that in this case, it actually doesn't matter. This court doesn't need to decide who has what ownership interest in the buildings at what time between the original owners and the original lessees, because all of that bundle of sticks went to brand new owners in this case. So this is actually the easiest case where no matter how you divide up kind of the ownership rights.
Unless one of those bundles of sticks is non-taxable. I mean, the reason why I sort of break it up in my mind is because the 17-year encumbrance on the land that the lessees hold, I think there is a concession that they could assign that. There is a concession that that is not taxable. And if that is actually the thing they paid all the money for, strikes me as obviously not the case. But that gets into some forfeiture issues. If that's the thing they paid all the money for, then it would seem you would want to carve that out.
Well, that's right, but and you're right that it strikes everyone is obviously not the case. But the point I'd make about the forfeiture point there is actually this is their forfeiture. They could have apportioned this out and suggested that some small portion of the $250 million that they paid went only to the lease termination insofar as it is ending the 17-year right to possess the property. But they didn't do that. They've never said that. So the only thing we have here is a transfer of land and buildings to new owners in exchange for $250 million. Now, they seem to be suggesting today that somehow what happened in this case is that they paid something like around $80 million for the land and the reversionary interest in the buildings, and then that the entire remainder of the $180 million was for, I guess, the remaining lease term, except that they're also not getting rent for that lease term. So that just is completely absurd. And it's an argument they have not made before. They need to make the apportionment argument if they're trying to get out of taxation. They can't just say, now for the first time that we never
said is you can't tax the lease termination. And at no point did you say, well, give me a break. $150 million for a lease termination is a freaking joke in this transaction. Get out of town. I think they did a portion. They said this giant chunk is for lease termination. And and the argument was always, well, you can tax that in a way that seems to run afoul of a lot of different practices that the district has followed. And the argument that the district offered was never really get out of town. That's not the right number.
I don't agree with you on that. And this is the reason. I think what we have said throughout this case is we are saying essentially get out of town because that remaining amount of the $180 million we have consistently said throughout this case was for the buildings. So that is our argument. It has been our argument from the beginning. I'm sorry.
How do we know that? How do we know it wasn't for the termination of the lease?
Because they've never argued it. This is the first time they're ever bringing.
That says termination says here's $180 million. We get the terminated lease.
Well, right, and then throughout. Fair enough, Your Honor. And then throughout this litigation, we've said, no, it was for the exchange of buildings. That's the only thing it could have been for. That's the only thing that makes sense. That has been the premise of our argument throughout this litigation. It's really the only thing we could be arguing in this case. I mean, what else could we possibly be saying here other than that $250 million paid for land and buildings, and they have to pay taxes on that? Then if they want to retort to us, no, that there's one amount of that $180 million that we paid for the buildings, and then there's another amount of that $180 million that we paid for the lease termination. I suppose that they could have done that. And
Well, I understood, perhaps I misunderstood, but I understood Mr. Darrington to be saying basically, I've forgotten the exact numbers. $80 million was for the building. And what is the rest? $150 million was for the lease termination. And if the district thought that's what the documents say, and if the district thought that's wrong, it was up to the district to say, well, that's a misallocation.
I just don't agree with that being the way that they've presented their case. They have never said that the $80 million was for the land and the buildings, and the remaining $170 million was just for the termination of the leasehold interest. They have never made that argument, because that argument doesn't pass the laugh test. I mean, that is just completely absurd.
What were the annual rents on that building? How much rent was that building bringing in?
I don't know the answer to that, Your Honor. I don't know the answer to that. My friend on the
You
other
don't think
side.
it was like $10 million a year, though?
No, I don't think so. Yes,
But they would have been paying themselves anyway.
they wouldn't have been paying that. Well, right. I don't know how the internal
No,
structure of
it was-
Vornado worked.
It could have been. Sure.
Right. I just make another point, though, which is that even if you think that the district somehow forfeited some entire argument about how the special warranty deeds work in this case, the ground lease terminations on their own effectuated a transfer. And the reason we know that it is the lessees that own this building is because they get to do all of the things that come with ownership. I think Judge Glickman, you brought up the point that, well, sure, you have these terms fee simple, absolute, and whatever, but at the end of the day, what we're really looking at is who owns them and what does that mean? And that means that the lessees get to depreciate the buildings on their tax returns, which is a huge tax benefit.
But
That
isn't that typical of a ground lease, though?
Sure.
But I thought you were telling me ground leases, a natural death effectuates no transfer.
Right. I think my point here is just that if you're in a world where the only thing you're looking at is the ground lease terminations in this case, those ground lease terminations effectuate a transfer of real property to new owners on their own. And you're right that a natural termination of a ground lease does as well. But in that situation, you just run into the problem that I mentioned in my opening, which is there's no execution of a document in that case. And again, this is never going to come up. That hypothetical is just never going to come up.
I appreciate the
because,
point.
And so, the lessees can also bulldoze the building.
I don't think I appreciate this will never come up point, because there's an inconsistency, isn't there, between saying at the end of the lease, the building will have no value, and an argument that, well, a lot more was being paid than just to get the income stream from the lease for 17 years.
Right. So at the end of a ground lease, when it naturally terminates, usually the building will have basically no value because it was put up decades earlier and it'll be basically
But if that's true, then the
dilapidated.
$150 million paid to terminate the lease was attributable to the lease payments, the lease stream.
I don't think that's right, because there were 17 years left on this lease. So those buildings still had quite a long life. I mean, those buildings are worth a lot of money. There's a giant.
What are they worth other than as sources of rent?
I'm sorry.
What are they worth other than as sources of?
Well, like this is exactly the point I'm trying to sort of describe, which is that you can depreciate that property on your tax returns, which is an enormous tax benefit to the lessees. You could improve them further. You could sell them to new owners. You could demolish them. You could and build something new there that might be worth more to you. So there's a lot of benefits to actually owning the buildings. And so it's quite clear here that the lessees own those buildings because they put them up and they benefited from all of those different ways in which they own them. So when that interest goes to brand new owners, you have to pay transfer and recordation taxes on it. And I think the final point I'd make on that is just somebody owned these buildings, right? Whether it's the original owners or the original lessees, and all of those entities were under the same umbrella company. So the strangest aspect, I think, of their argument is if you had been in a world where it was just a common law rule and the ownership of the buildings was in the original lessor, which is also a subsidiary of Vornado. In that world, if Vornado sells the land and buildings to new owners, everybody agrees that they would pay transfer and recordation taxes on the land and the buildings, the full consideration. So the only thing that's different about this case is that Vornado has chosen to internally structure its subsidiaries such that a different subsidiary owns the lease term and the buildings compared to the subsidiary that owns the land. That internal structure within Vornado cannot form the basis of avoiding millions of dollars of tax of a conveyance that everybody agrees transferred buildings to new owners. And just on the final point about the Acme and Expedia rule about the canon of statutory construction, that canon really only comes into play, as this court explained in Expedia, after two initial steps. The first step is the plain text of the statute doesn't clearly answer the question. And then the second step is, after looking at all of the canons of statutory construction and the legislature's intent and any absurdities that might arise, you still have no, basis to go one way or another. It's still kind of a wash and totally ambiguous. Then, of course, you may end up favoring the taxpayer over the government. But here, I think all of the absurdities that we've explained in our brief, whether it's opening up a massive loophole that the council could never have intended, or just this kind of absurdity of Vornado being able to structure its subsidiaries in a way that allows it to avoid taxes where another structure within those same subsidiaries would result in tax. That just doesn't make any sense at all. And when you get to that second step, at least of Expedia, I think this case answers itself and the canon doesn't come into play. I'm happy to answer any other questions the court might have. Thank you.
Council, thank you all. We're going to, the case is submitted. We're going to take a 5-minute recess and then we'll resume.
All right. The court will take a short recess. The first case so they submitted a order additional amount of time. Oh. So it's 15 minutes. Right, if you go to 15 minutes, then I was at the time of 2 or 3 minutes of traffic. Well, you can't say that. All right. Court is now back in session. You may be seated.
Good morning, council. If it is still morning. We're calling the third case on the calendar, in re Larry Smith.
Good afternoon, Your Honors. If it please the court, my name is Pierre Bergeron. I represent LS.
You know what? I'm going to ask you, if you don't mind, to possibly raise the podium so that the mic is closer to your. I want you to get a little bit closer to the microphone, if you don't mind.
So, Your Honors, this is a case of a 71-year-old clinically diagnosed severely intellectually disabled individual who was told by the mental rehabilitation court in 2020 during the pandemic, at the height of the pandemic, and before the vaccines, that he could go back to supported employment within the general public at the Department of Defense if he wanted to, because the probate court only limited his medical decisions making and only appointed a limited medical guardian. Mr. LS was denied the right to seek quick and timely protection from the mental rehabilitation court, which could have been deadly for him, as it has been for 38 deaths of individuals who died while under the supervision of DDS, and 76 individuals died who were connected with DDA, and 687 persons connected with DDA contracted COVID-19, making them vulnerable to long-haul effects.
And what remedy are you seeking now?
I have 4 remedies, Your Honor. I think the issue here is forum. What I seek from the court first is a clear statement that the health and safety and capacity to make all decisions of committed intellectually disabled individuals is under the jurisdiction of the mental rehabilitation court.
So counsel, can I just pause? Usually a clear statement is not the type of thing that I would describe as a remedy. That could be an advisory ruling. My question is, what tangible thing, what tangible interest remains? And this goes toward a standing and mootness concern. What is the thing that you want other than us to sort of articulate some laws, which to me feels advisory?
Well, if I may continue.
Sure,
I
sure.
have a.
I apologize for interrupting, please.
The questions of health and safety and capacity also must be submitted to an evidentiary hearing when requested by a party. The issue here is a conflict between the guardianship law and the mental habilitation law. And the guardianship law shifts everything towards guardians, and there's no power over DDS. What I'm asking basically is that the mental habilitation law is basically be the primary law that governs people with intellectual disabilities. Why? Because the definition of them, their definition in the statute indicates that according to the mental disorders, they do not have capacity. Therefore, the mental habilitation statute has a parents patriae obligation, as well as there are statutory rights that protect these individuals. There needs to be a clear ruling that the mental habilitation jurisdiction preempts the limited medical guardian and general guardian and probate courts jurisdiction. There's been a shift towards guardians at this point. Guardians are subjective. They do not have an evidentiary hearing. I once had a case where I was a guardian, got a substitute guardian because I was in Japan, and the substitute guardian put this individual into hospice care. He could have died. And when I came back, basically reversed the whole process. The issue is that there needs to be, whenever there is a conflict, as it has been here, there's been a conflict here with the IDT team, there's been a conflict here with 2 judges, and there's been a conflict here with DDS. There needs to be an evidentiary hearing. That should be a right, and that the health and safety in the habilitation context, not medical decisions, but health and safety in the habilitation context needs to be able to be aired out. In this situation, had we had an evidentiary hearing, we would have been able to at least iron out whether in fact his life was in danger or not. And if I was not satisfied with that decision, I could have come to you. It is the court's responsibility for these individuals. The problem that they were abused in the past is that because discretion was left to DDS, to bureaucrats, and to guardians.
Mr. Bergeron, I think I got lost in trying to list your 4 remedies that you're seeking. I think I have 3 and maybe you mentioned some others. So the first one had to do with a clear statement
A clear
that
statement.
the questions of health and safety are under the jurisdiction of the habilitation court. Is that number 1?
Yes.
And number 2 had to do with having an evidentiary hearing on such matters
When requested by a party.
when requested. And number 3,
A clear ruling that
A
the mental
ruling.
habilitation jurisdiction preempts the limited medical guardian and general guardian and probate court jurisdiction.
all right, and what's number 4?
And number 4, in this case, the final order giving LS a final decision as to whether he should return to work is to be reversed, irrespective of the wishes of the general guardian, that an evidentiary hearing should be held upon request of a party. I'm not asking to go backwards at this point. There are vaccines. But the issue is that if the vaccines don't work tomorrow and he's still at work, I've got to take some action here. And he needs to be protected. There needs to be an evidentiary hearing. I can't have DDS or a guardian say, oh, it's fine. You know, we've had, they returned him to work and everybody was muffled. And we had court hearings, you know, that were at home, that were basically virtual hearings. And yet here he was at work in the general public. This is a contradiction at this point. It was a legal fiction that was done between the probate court, saying his rights were not terminated in terms of making habilitation decisions, therefore he can make his own. And yet you have psychologicals that indicate that he cannot make those. It was a pure conflict. I'm asking you to reverse, to basically remedy the situation. There is a conflict between the guardianship law, the mental habilitation law, which endangers the lives of these individuals.
Mr. Bergeron, I think it's easy to agree that these are important questions you raise, and, you know, you're to be commended for protecting your client's rights in this way. But I am trying to figure out why this is not moot now. I looked back at the original motion, emergency motion you filed in both the probate court and the habilitation court, actually. You said that what you were looking for is an order that Mr. Smith should stop attending his supported employment until the court could assess his ability to assess his capacity to assess the health and safety risks of returning to work. And what has happened since that time, among the things that have happened since that time, is that the probate court has determined that Mr. Smith does not have the capacity to make that kind of assessment and to make decisions for himself, and a general guardian has been appointed. And so an order that would ask or require the trial court to assess his capacity to make the decisions is not an order that needs to be made now. The determination has already been made that he lacks that capacity. Is that not right?
No, Your Honor,
Why
that
is
is
it not right?
basically a subterfuge that is being used by DDS. They're using general guardians and limited guardians to escape the overview of the mental rehabilitation court to basically order them to restore services or to inhibit return to work if in fact the pandemic occurs again, or there are new variants, or there are new, I mean, we're living in an age right now where we can get, you know, a new pandemic anytime. Monkeypox is just an example. So tomorrow, we may be at the same point that we were 2 years ago, where we have a pandemic. And so who's supposed to make that decision? A guardian, a lay person? The guardianship statute was
Counsel,
basically.
are you sort of invoking a capable of repetition yet evading review exception to the mootness doctrine?
Yeah, it
This
is.
could happen. I could again find myself in this position,
Yes.
and there's no time to kind of give myself a remedy. Did you seek an emergency stay with this court or injunctive relief of some form?
I'm not seeking an injunction.
No, I mean, did you back before this arguably has, you know, it sounds like there's no relief for Mr. Smith right now.
There is relief. There is relief that if in fact that I have a right to go to court and basically ask for an evidentiary hearing, and that health and safety are in fact within the jurisdiction of the mental rehabilitation court. Right now, I'm not able to do that. And it's being deferred to general guardians and to limited guardians. Where in the probate statute would you find that the probate court has any jurisdiction over DDS? In fact, DDS in its own brief admits to that, saying we will always comply with orders from the court. Well, there are hundreds, if not thousands of orders bringing DDS into compliance. In fact, in this case, on October 2nd, there was a second order that restored speech and language. And so the DDS had actually withdrawn speech and language services, and the court ordered it. Now, I don't think that we can need to confuse the injunction, and as well as emergency orders. I chose to do both in order to cover all bases. However, there have been, you may want to check the mental rehabilitation clerks. There are hundreds, if not thousands, of orders bringing DDS into compliance. General guardians, limited guardians do not have the capacity to order DDS. The probate court has not been
But
ordering.
they can go to court and ask for an order to bring DDS into compliance, right?
They may, the question is whether, they may go to court if you wish, but at the same time, if the decision is deferred, if the judge in this case says, I have no jurisdiction over the mental rehabilitation of Mr. LS, because in this case, it's considered to be a medical issue. In this case, what you had is two different things. The probate court said, I have no jurisdiction because a medical consent is not being asked. The probate court said, oh, this is a medical decision. So what happened? He was in a vacuum. He was in the middle. A man who basically is severely intellectually disabled was led off onto a cliff, saying, oh, you want to go back to work? Go back to work. And he was abandoned. And that is the abandonment that took place in this case that brought, the Evans suit. Well, what is being risked here is going backwards. And if you entrust simply the decision to make decisions to limited and medical guardians or general guardians, then you have that subjectivity that is not being challenged at this point. If the court says, I don't have jurisdiction, then they just simply defer to the general guardian or the limited guardian. And the probate court, if the DES says basically we're going to comply with what the general guardian says, there is nobody to order DDS to actually go and fix the problem. Because the probate court doesn't have jurisdiction over DDS. And in this particular case, the mental rehabilitation court has deferred to general guardian and limited guardians.
Well, if you think that the general guardian is consenting to a client going to work in a place that is unsafe, unhealthy, toxic, as you put it, there is a remedy in the probate court. You tell the probate court that the guardian is not fulfilling his or her duties. You ask to have the guardian removed and replaced, or you ask the court to direct the guardian to do his or her job. There's a remedy. The problem you ran into before is that you filed this motion in both courts, and the probate court said, this is before the habilitation court. It's irregular to bring these proceedings in two courts. I'm not touching this, the court said. I mean, so there is a remedy there.
No, there is not, Your Honor, with all due
Why not?
respect, because if DDS says we agree with that, then DDS basically is not under the jurisdiction of the probate court.
Well, DDS's position, according to the record, has never been that Mr. Smith must go to work. DDS apparently arranged for a supportive employment arrangement for him and ascertained that he wanted to go. Now, there's an issue of whether or not he was able to make that assessment, and I think that got resolved through the appointment of the general guardian. But DDS, I don't think, has been forcing Mr. Smith to go to work.
No,
Isn't that correct?
But they should have prevented him from going to work. They should have stopped him. I basically, no matter how much I basically complained and said, he should not be going to work, DDS says he is going to work. And there was nothing that I could do at this point. And even with the general guardian, the general guardian basically there needs to be a very clear statement that the general guardian is under the jurisdiction of the mental rehabilitation court. And not just the probate court, but the mental rehabilitation court. And second, that DDS basically must comply with the mental rehabilitation court in health and safety matters, and that otherwise there are no other courts that will do it.
Well, I think there's still a question about whether that relief is needed now in this case. I mean, mootness is still an issue. When you filed your emergency motion, you said to the court that Mr. Smith has been going to his employment situation, even though court is closed, the DDS workers are working at home, the Department of Defense workers are working at home. COVID is rampant, people are dying, there's no vaccine, et cetera, et cetera, et cetera. And we're far from that now. I think the experts are telling us we're still in a pandemic and there surely still is some danger, but people are going back to the office, and it's not the circumstance that you described to the court initially. It doesn't seem that you need the relief.
There's a sign that went on the outside that says you must wear a mask inside the courtroom. There's all kinds of purifiers. There's a chart that says this courtroom has been disinfected. We're still in the pandemic. There are still 400 people that are dying a day. And if I, in fact, find that Mr. Smith is in danger because there's a resurgence of the pandemic, which can happen at any time, I have no remedy right now. Why? Because the general guardian basically says he should just continue going to work like she has in the past. DDS is in cahoots. DDS is the one that petitioned the limited medical guardian to become the general guardian. And so it was basically, they were basically in agreement. I was totally helpless at this point. I had no remedy. And this will continue
Counsel,
because tomorrow.
I'm not sure I heard your answer to Judge Thompson's question. I might have just missed it. There's no remedy to ask the court to remove the general guardian?
No, there's
You
no,
can't petition the court to have the general guardian removed?
it's very difficult to do.
I'm sure it is. I'm just,
But that's not where the emphasis. We have a Mental Rehabilitation Act. And this is what I'm asking you to look at this point. The Mental Rehabilitation Act there is a difference between the guardianship statute and the Mental Rehabilitation Act. The Mental Rehabilitation Act was enacted for past abuses. It is a Parens Patriae Act. It is an act that is remedial in nature. Why? Because the individuals that are in the Mental Rehabilitation Act, under the Mental Rehabilitation Act, are often abandoned. There's nobody, there's no family. When you're appointing general guardians and guardians, many times there are families. The families would look for the best interests of their family member. That doesn't work with intellectually disabled. And why? Just look at the history. Just read Evans. They were abused tremendously. And this is basically the inception of trying to go back to that abuse by leaving it to the discretion of lay people without an evidentiary hearing where you have experts and you have individuals with different views that can air them. And in fact, they end up in your court if there is a difference. Because the life of one individual is worth basically an evidentiary hearing, is worth the Court of Appeals time, is worth the Mental Rehabilitation Court's time.
Did you actually seek an evidentiary hearing about the health and safety conditions at the workplace?
Yes.
For Mr. Smith? As I
Yes.
read the transcript, the conversation with the court focused on witnesses who would have testified that they heard Mr. Smith say that he would be fine with not going to work. It was testimony that the court said was going to be hearsay in any event, but that's the focus of the proffered testimony. It was not about
No, it was. I mean, no,
about the workplace.
the judge denied. She says, I will not hear any testimony. If you look at the transcript and look at the order of October 1st, I will not hear any evidence on his capacity or on the condition of the workplace. She ruled that out. She threw that out completely. She says, I have no jurisdiction on that. And that's the mistake.
Did you proffer that you had witnesses to
Yes, I
testify
did.
about
I proffered that
about the conditions in the workplace?
it was difficult to do that. What I did is I submitted articles that had scientific studies about the analysis of the transmission of COVID-19 in public places. Remember, this was at the beginning of the time. There was no case law. I was working with what I had at this point. And so, but she basically denied, she says, I will not entertain anything with regards to the capacity of the individual or of the workplace. And this is basically, it contradicts Evans versus Fenty, and it contradicts JJ, that the habilitation environment, and if you look at the statute, there are consistently in the statute, it says basically that part of the habilitation is to be able to help an individual adapt to the environment. And this is basically in DC code 713010314 and the definition of habilitation. 71305-01, habilitation and care, cope with the environment. 7130502, cope with the environment. And then 713-0406, evidentiary hearings, 734-11, review of commitment, where they must find that the individual is moderately retarded, or intellectually disabled. And the definition of moderately intellectually disabled, at least a moderate intellectual disability means a person who is found following a comprehensive evaluation to be impaired in adaptive behavior to a moderate, severe, or profound degree and functioning at a moderate, severe, or profound intellectual level in accordance with the standard measurements as recorded in the Diagnostic and Statistical Manual of Mental Disorders. And if you look at my reply brief, I go extensively in that particular fact. The mental rehabilitation statute is clinical in nature. The probate court is basically legal in nature. You have a legal fiction, but the mental rehabilitation statute is basically clinical in nature. And it goes, the manual goes into a competency. And if you look at the psychologicals of Mr. LS, both 2008 and the most recent one by which they petitioned the general guardian, he was found to be non-competent to make habilitation decisions. So you have the probate. So the court says they didn't find him to be not competent to make habilitation decisions. And then you have a psychologist that says he can't make decisions. So therefore, what are you gonna do? Let him lead off a cliff and say, go ahead. You know, you haven't been found by the probate court. So basically the mental rehabilitation court is basically washed down the drain. And that's what I'm asking you basically is to put some teeth in the mental rehabilitation court to protect these individuals. And not leave it to the discretion.
Counsel for the district.
I'm sorry?
Let us hear now counsel for the district and how she responds to your arguments, and then we'll give you a few minutes in rebuttal.
Thank you.
May it please the court, Stacey Anderson on behalf of the Department of Disability Services. Your Honors, we'd ask that the court dismiss this appeal as moot because the only meaningful relief that was sought here was a determination as to Mr. Smith's capacity to make decisions regarding his habilitation. And that determination has been made since this appeal was filed. Following a psychological evaluation that was discussed at the September 17th hearing before the magistrate judge, Mr. Smith did undergo another psychological evaluation, an updated psychological evaluation. And based on the recommendations in that evaluation, DDS did petition the probate court for the appointment of a general guardian and went through that process of having a judge make the determination based on the robust procedural protections afforded people with intellectual disabilities in where there's someone seeking the appointment of a guardian. So we went through that process and the court ultimately concluded that Mr. Smith did lack the capacity to make habilitation decisions and has since appointed a general guardian as a substitute decision maker who is bound to exercise substitute judgment, or if substitute judgment can't be made based on what the guardian believes Mr. Smith's wishes to be, then on his best interests. And the best interests, again, go to weighing all the pertinent and available factors, including the risks, the benefits of the particular habilitation that's offered. In this case, Ms. Dawson has been appointed in that role and has determined in Mr. Smith's best interest and through substitute judgment that he should continue with his employment.
Well, here's what counsel said, Mr. Smith's counsel said in opposing your motion to dismiss. He said that his client should stop attending supportive employment until an effective vaccine is found, or until further order of the court, wherein the court could do two things. The first one was assess the evidence on Mr. Smith's capacity to assess the health and safety risks of returning to work. I think you've just addressed that. The probate court addressed that in the appointment of a general guardian. But prong number two was until the court can assess the health and safety risks of the habilitation work environment. Is that part of the relief sought?
I believe it is. I would say no, Your Honor. It's not, but I would say that on that request for relief, that's not the role of the habilitation court. The role of the habilitation court is to ensure that DDS is providing habilitation services that are in compliance with the individual habilitation plan. There's no dispute here that Mr. Smith's supported employment was an appropriate habilitation for him, and that Mr. Smith's job was appropriate for him to further the goals of his habilitation plan. He had been employed in this role for a number of years before the pandemic. When the pandemic came, his employer suspended the program. And then when we were in phase 2 reopening, made a request to see if Mr. Smith wanted to return to the employment under the CDC's personal protection protocols. Mr. Smith was given the choice of whether to return or not. DDS did not force him to go. At that time, Mr. Smith was presumed to have the capacity to make that decision for himself. He was given a choice. The foundation of the habilitation statute begins with a presumption that persons with intellectual disability are able to make decisions about their own habilitation until there's been a judicial determination that they lack that capacity. And at the point in time where Mr. Smith was asked to make a choice, he had presumptively the capacity to do so. In terms of the judge's role in assessing the habilitation plan that he's under and the services that DDS is offering, it's the judge's role to make sure that DDS is complying with the statute. And here the statute simply requires that DDS afford him a program that is geared towards maximizing his normalcy, providing him services when in the least restrictive environment, and also ensuring that goals are being met in terms of if he doesn't wear his hearing protectors, or even if he does, there may be some risk of hearing loss. As a person who's presumed competent, Mr. Smith has a right to make the decision to assume that risk in furtherance of his goals of employment. And the same is true here too. Mr. Smith had the right at the time of the decision to choose to accept the risks and the benefits of returning to employment. And he has that right to self-determination under the Habilitation Act. It's only where DDS is failing to comply with the requirements of the statute that the court plays a role. And I can give you an example. One of the rights that's guaranteed by the act is the right to prompt and adequate medical care. So for example, if Mr. Smith fell and broke his arm and DDS scheduled an appointment 3 weeks later with someone who wasn't licensed to provide medical care, clearly that would not be prompt or adequate medical treatment. But if DDS took Mr. Smith to the hospital and the hospital diagnosed his broken arm and said, Mr. Smith, you have two options. One, you can undergo surgery. We can put a pin in your broken arm. It will heal quickly and you won't risk any loss of use. But there are risks. You're an older gentleman. You may have some other underlying medical conditions. So anesthesia may not be the best thing for you. The second option is we can set the bone as best we can, put a cast on. There'll be a long recovery. You may lose some use of your arm. It's up to Mr. Smith to make the decision as between those two. We don't go to court and say, hey, court, we think Mr. Smith made a bad judgment call here. So you need to substitute your decision for his. That's not how the system works. He's presumed competent. And if there's a finding of incompetency, then it's the guardian who goes through that decision-making process. And as Judge Thompson, you pointed out, if the guardian is not fulfilling the obligations, the fiduciary obligations under the Guardianship Act, the remedy is to go to the probate court and seek redress through either the appointment of a different guardian, an appointment with special instructions as to how to carry out particular decision-making, but there is a remedy available. But this is how the council has set up the system. And this is the system in which the court properly was operating here and declining to A, consider Mr. Smith's capacity, or B, to substitute her judgment, the court's judgment, for Mr. Smith's decision to return to work, knowingly assuming the risks that might entail. Again, and the court pointed out, there are, people have different views about the pandemic. People have different views about when it's appropriate to return to work and not to return to work. And as a person with the right of self-determination, like everyone in this courtroom, Mr. Smith had the right to choose to go back to work during the pandemic under the protections that were offered by DDS. And he also had the right to refuse. And in this case, he accepted that. And there really was no role for the court to play here beyond again, considering whether DDS was providing the employment that he was required to have and that the particular job fulfilled his needs.
At the point in time when Mr. Smith's emergency motion was filed, when we were sort of at the height of the pandemic and pretty much everybody was staying home and restaurants were closed, you know, by order of the mayor, and all of the extreme provisions were in place. Was there a point in time then when a decision by DDS to allow Mr. Smith to go to the supportive employment arrangement it had set up would have been something that should have been attended to by the habilitation court? I mean, was there an argument that at that point in time, DDS had crossed a line and in providing or arranging for supportive employment, but in a way that, to use Mr. Bergeron's word was toxic and therefore contrary to the client's interests?
No, Your Honor, I don't, because again, we begin with presumption. First of all, DDS was not sending him to work. DDS was simply providing a service that he's entitled to under the statute. He has a right to employment. He has a right to habilitation consistent with his habilitation plan. No one has said that employment.
If DDS just failed to make arrangements for supportive employment, that's something that could have been.
Yes, and that's the typical. Yes, Your Honor, that's the typical case we have where DDS fails to provide the supports it's supposed to. If it had refused, if Mr. Smith had gone to DDS and said, I want to go back to work at the height of the pandemic, DDS said, no, you can't. That would be where the court should be stepping in and saying, no, Mr. Smith has a right to go back to work. Again, assuming his competency to make the decision, he has the right to assume those risks. Just again, as I said, any other person in this room, there's that presumption. If he lacks the capacity, then again, we go through the guardianship route. And if that was a current concern by the court, DDS, you know, that should have been the focus of making sure that he got a guardian appointed through the probate process. But it is Mr. Smith's right to make that decision. And employment is a right he has protected under the statute. So, for example, here, you know, we talked about DDS made arrangements for him to follow all the CDC protocols. Maybe Mr. Smith didn't want to wear a mask. If he's competent to make that decision, then that's his decision to be made. That is how the system is set up. It's not the court's role to decide what's best for Mr. Smith. The court's role is to decide to make sure that DDS is providing the supports it's supposed to be providing. And again, I give examples of prompt medical care. There's housing requirements, there's dietary requirements. There's several things the DDS is responsible for providing. And the court's role is to make sure that those statutory requirements are being met. But as far as Mr. Smith's decision-making, as long as he's competent, those are his decisions to make.
There was some discussion in the annual review, I think, that took place in October of 2020 about some of the provisions that the not the foster home, the group home provider, some of the steps it was taking to keep Mr. Smith safe, laundering his clothes when he
Correct.
got home from work, and
Yes.
transporting him to work, and providing a mask, et cetera.
Right.
Were those legitimate inquiries by the habilitation court?
Possibly, Your Honor. I mean, he had a right to residence, that, you know, humane residence in that respect. But again, I think to the extent that Mr. Smith agreed to those services, there would be no reason, I think, for the court to get involved. Again, this all assumes that he has the capacity to make decisions about himself and what habilitation he's entitled to, and we'll see. We may offer him employment. He may not want to have employment, even though everybody else thinks it's in his best interest to have employment. But again, it's his choice. The focus really is on self-determination and normalization, and providing, again, habilitation in the least restrictive environment. And employment here was in the least restrictive environment. And Mr. Bergeron has argued, well, he was doing household chores, but that's the most restrictive environment. He was given the option for a less restrictive environment, was free to choose it.
Is it your view that the case is now moot?
Yes, again, by virtue of the appointment
The appointment of the
of
guardian.
the substitute decision
And
maker. yes.
there's no further proceeding pending in the guardianship court at this point.
And not at this point, no, Your Honor. It's subject to review every 3 years, and again,
Right, but
subject to,
nothing at the moment.
yeah. correct.
Mr. Bergeron seems to think that there is a need for this court to provide some clarity about the relationship between the habilitation court and the probate court, and the probate court's relationship with DDS. In your experience in these matters, is there some pressing need for that? That doesn't really answer the mootness question, but I'm just curious.
No, Your Honor, I think the statutory scheme is quite clear as to what role is to be played by, each branch of the Superior Court. And I don't think there's any conflict. I mean, as you'll notice, Ms. Dawson has been present throughout the proceedings. She's now his general guardian. She's part of his interdisciplinary team. She's involved before her appointment as a general guardian, she was involved in the habilitation court and consenting to his voluntary commitment to DDS. So there's no, the guardian's not off doing her own thing, and she's highly involved in the decision-making process. And in terms of directing DDS to do anything, I'm not certain that there's really anything that fall within the scope of the probate court's purview that would require it to order DDS to do things. Certainly the habilitation court would have that authority. And the guardian can certainly, again, as a general guardian making decisions with respect to habilitation, can go to the habilitation court with concerns and say, hey, DDS is not, he's supposed to, have his annual physical. He didn't get his annual physical this year. You need to order DDS to get it for his annual physical. So, I mean, I don't know that there's any clarity. And again, counsel.
Do you think Judge McLean was right when she said that the habilitation court had no authority to issue the requested injunction?
I think she was responding. Well, I agree that no, she didn't have the authority in the sense that this really doesn't fall within the purview of the habilitation court to, for example, determine Mr. Smith's capacity. That again is under the intervention statutes. But in terms, I think that really was focused on the nature of the relief which was sought, which was an injunction as a
language, therapy, services, and I think there.
in really the antithesis of the Habilitation Act. And I think that was the point there, that what he was seeking was relief that just simply wasn't available under the act, and therefore she lacked the authority to grant it. If that answers your question. If there are no further questions, we'd ask the court dismiss as moot or otherwise affirm. Thank you.
Mr. Bergeron, I have a question for you. And I mean no respect, but no disrespect, but I would like you to clarify something for me, and that is, and I don't know how to put this better, but your standing, as it were.
I'm sorry.
I'm sort of wondering about why it is exactly you, as counsel for Mr. Smith, have standing to pursue the relief you're pursuing. What's puzzling me a little bit is that you're pursuing something that is, by your own admission, contrary to what Mr. Smith has said he wanted. And to the extent your argument is, well, Mr. Smith was not really competent to express his wishes or to make a determination of what is in his best interest. He has a guardian, and the guardian has not sort of, in effect, the guardian becomes your client, one might say, I suppose, but the guardian has not asked you to pursue this relief. And I'm wondering why, maybe you just could clarify for me your status as someone who can pursue this relief when it's not something your client or your client's representative is seeking.
I think it's a good question, Your Honor. I did ask Mr. Smith many times if he wanted to wait until there was a vaccine or until it was safe, even when there was a vaccine, and he agreed to. But then his ability to comprehend varies. And so if DDS says, oh, he says he wants to go to work, and then I ask him the same question, and it all depends how you phrase it. Remember that the HRC, the human rights component that says it's Mr. LS should go back to work is part of DDS. There was also another issue, and that, I sort of questioned this myself. I went to Bar Council to get a clarification. And I was told basically, if you use the rules of conduct 1.1.4b, when the lawyer reasonably believes that the client has diminished capacity, is at risk of substantial physical, financial, or other harm unless action is taken, and cannot adequately act in the client's own interest, the lawyer may take reasonably necessary protective action, including consulting with individuals or entities that have the ability to take action to protect the client, and in appropriate cases, seeking the appointment of surrogate decision maker. Here, I sought the help of the court. I sought the help of the trial court.
Mr. Bergeron, do you think that applies when somebody has a general guardian? The way that concluded was roughly seek the appointment of a general guardian, if you think that. And when somebody has a general guardian, I would think that rule really only applies if you think the general guardian is incompetent or incapacitated in some way. In my mind, and it's just to give you a chance to respond. In my mind, the general guardian is somebody who's standing in the shoes of somebody who is otherwise incompetent to make their own decisions. And here, that person who is standing in Mr. Smith's shoes is you are adverse to, despite on paper representing Mr. Smith. That strikes me as you are working against the interests of your client as represented by a general guardian.
No, Your Honor, if I would have been allowed to provide testimony, the group home people indicated that Mr. Smith was just as happy being at home as if he was at work. It was a question of programming. Mr. Smith is very active. And so what they did is they developed a schedule that was analogous to the schedule he had at work, and he was happy. And I was going to put that testimony on, and that was denied. I could not put that testimony on.
At one point, you told the habilitation court that you thought, or you agreed, I think with the court, that the appointment of a guardian ad litem might make some sense. What did you think that person would do? Different from what you were doing?
In all cases, whether it's a guardian ad litem, a general guardian, a limited guardian, the ultimate arbiter should be the court. They can make recommendations to the court, but to leave the decision to guardians at this point is opening the door to abuse. Like I said, I almost lost an individual when I was in Japan, and I had this substitute guardian, as I've been a guardian before, who basically decided to put him in hospice and let this individual die. You cannot put life and death decisions, in the hands of lay people who have have very limited background. They're members of the bar. Wonderful. That's not enough.
Actually, the guardian in this case, I was under the impression the guardian in this case is a bit more experienced than just an ordinary layperson. Am I wrong about that?
The guardian in this case has been in sync with DDS all the way. If you look at the history in this case and you look at the record, she's never disagreed with DDS. And it is kind of interesting that a year and a half after the pandemic has been in effect, DDS decides, oh, maybe we should have a general guardian. What was it? It was basically a litigation tool. They were simply trying to cover themselves, and they were trying to get the case dismissed based on mootness by appointing a general guardian. There was absolutely no interest for a year and a half in protecting Mr. Smith. Why didn't they seek a general guardian at the beginning rather than wait a year and a half and risk his life? And this can happen.
What did you think, though, that the guardian ad litem would do, to get back to my question?
The guardian ad litem basically could have made recommendations, but the final decision was still the habilitation court, and the habilitation court refused to do it. It does not get you any place if you have a guardian at this point as being the ultimate arbiter. The ultimate arbiter has to be the court when in fact life and death issues are at stake. That is the worth of a life.
Do you happen to know whether your client is working now in the supportive environment?
He is working in a supportive environment at this time, but if the pandemic, if there's a new variant that comes out tomorrow, we're all going to go home and he's going to go back to work. And that's the problem. And I have no recourse because the guardian has been agreeing with DDS all along. Oh, he's fine. And you heard basically from DDS a contradiction. She said, we petitioned for general guardian because he's not competent. And then two sentences later, oh, well, but he is competent to make decisions. You had two contradictory statements made in the same.
I think what you said
presentation.
was he was presumed competent under the statute until they went through the process of appointing a general guardian. I don't think there's any contradiction there. I mean, somebody could have petitioned to have a competency screening, or I don't know the exact mechanism. But I take it you just meant there's a statutory presumption until found otherwise, and now it's been found otherwise, which I think you would agree was a responsible move to have general guardian appointed. Sounds like you don't like the particular general guardian, or don't think she's acting in his best interest, but that's kind of another matter. I guess I just don't see the contradiction.
Because in fact, that's precisely the contradiction that I'm asking you to resolve. Because the definition of moderate retardation, at least a moderate intellectual disability, means a person who is found following a comprehensive evaluation to be adaptive, to be impaired in adaptive behavior to a moderate, severe, or profound degree, and functioning in a moderate degree, severe, or profound intellectual level in accordance with the standard measurements as recorded in the Diagnostic and Statistical Manual of Mental Disorders. So if you have the probate court that decides one thing on a legal level, but then you have clinicians that decide another, then in fact, it is the responsibility of the mental rehabilitation court to assess those evaluations in light of its own structure. The mental rehabilitation court has periodic reviews where they must decide whether an individual can continue as a moderate individual. It has evidentiary hearings. All the mechanisms are there. The mental rehabilitation statute was basically enacted to protect individuals who are abandoned and who have been abused. That's what should kick in, not whether in fact there's been a determination of competency in the probate court. And most of the statute of the probate court has to do with healthcare decisions. We are not talking here about healthcare decisions. We are talking here about the health and safety of habilitation, which is totally a different thing. And in as much as that is, if you look at the statute, there is a lot of protection at this point in that area. That statute has to be enforced, not only for speech and language, but where it counts, health and safety, and that's under Evans and Fenty, and that's under JJ. JJ made it very clear that there are responsibilities with regards to the health and safety of individuals, and that it is a responsibility of the mental rehabilitation court. And I'm asking you basically to put some teeth in the mental rehabilitation court to take control and not to be dominated by general guardians and by legal fictions that can endanger people's lives.
Counsel, thank you both. Case is submitted. And the court will now adjourn.